non-prosecution.
If your lordship may kindly
mentioning,
no, not mentioning, my lord. It's for leave, my lord. My lord, it's a urgency is that me and my husband, we are elderly couple, and my son and daughter-in-law is staying with us. And first they were abusing us verbally, and now it has taken the shape of physical assault, my lord. They are threatening us that if we do not transfer our property in their name, they will kill us, my lord. Our lives are at stake, my lord. My lord, kindly hears it any day next week, my lord.
Under this determination, what will the court do?
My lord, kindly direct them to.
Them means who? The court will direct the private parties now. A writ of mandamus will be issued against them.
No, my lord, the
Then what?
mandamus against the.
If you have any grievance against the police, you go before the police in action bench. Why here?
But my lord,
Lordship, under compelling circumstances, I'm mentioning, Lordship, the 25 street vendors, Lordship, before your Lordship, within the meaning of Section 2(1) of the subsection 1 of the Vendors Act, Street Vendors Act 2014, Lordship. Lordship, what has happened, Lordship, on 21st of August, Lordship, they have pasted one note.
Means?
Lordship, the executive engineer within the Bidhannagar Municipal Corporation, Lordship, we are running more than 20 years, Lordship.
Yes.
Lordship, what has happened?
Why don't you go before the corporation bench?
Lordship, the difficulty is that they have given an eviction notice and 15 days time had been given, Lordship. We have made a representation.
Executive engineer of the corporation.
No, Lordship, Bidhannagar Municipal Corporation, Street
Yes.
Vendors Act, Lordship, which is within your determination, Lordship.
It is within the corporation
Lordship,
determination.
kindly, Lordship, otherwise I will be
My lord.
difficulty, Lordship, kindly, Lordship.
Go before the corporation bench, get it done.
Lordship, this is within your determination, Lordship.
How can it be? It's the executive
Act 2014, Lordship.
Whatever act has been invoked is not important. Important is the person who is invoking. It is the corporation's excess action that you are challenging. Why don't you go before the corporation bench?
The difficulty kindly hears me.
I will not hear. Please, sorry.
May I have, my lord, kindly, my lord, this is an application for vacating interim order. It has been notarized in Delhi. My lord, the department says that though this is a bond, this is not the bond that is accepted here. My lord, I was only seeking leave to file it with this, my lord, because it's been notarized and everything has been done, my lord, from Delhi.
In the appellate side it is.
Yes, my lord, the appellate side.
एक खोज निये देखुन की आचे. You give. He'll inquire.
My lord, Mr. Bose is there virtually, my lord. My lord, I had mentioned this matter yesterday, if your lordship recollects, my lord. This is that suspension of the petitioner, my lord. Your lordship.
My lord, may I just indicate this, my lord? My lord, this was mentioned, my lord. The difficulties that I'll tell you, lordship. This is an e-government portal for e-tendering. My lord, this is a pan-India, all-India tender. I have been suspended for reasons which are not only arbitrary, but in wholly colorable executive authority. Now, my lord, what is happening is that because of the suspension, I am not being able to participate in any tender anywhere in India. So, my lord, this suspension will continue to the 28th of September. By then, my lord, my business will close down. And my lord, I have been in business for the last 50 years. And I do not have, my lord, even one suspension in the last 50 years. And my lord, the work that I have done for Indian Oil, work completed, completion certificate issued. So the reason for suspension is that I am not willing to accept the extension. You know,
Yes.
I am not being able to participate also.
Yes.
That is the difficulty. You know?
This is a system gem. So what can be done?
But the difficulty is that because of the suspension, so far as this contract is concerned, I am acceptable. But I am not being able to, they are not giving me logging. But I am not being able to even log into the portal for the purpose of participation in any tender. Not only this tender. So basically, effectively, my right to carry on business has been suspended.
Yes.
But ad nauseum suspended ad nauseum. So this is, well, actually, if I tell your lordship the facts, your lordship will, it will shock your lordship conscience.
At the mentioning stage, the court is not concerned with the facts. It's only the urgency that the court looks into.
Correct. Yeah, this is the urgency, my lord. I cannot participate in any tender anywhere in India.
Has it been filed yesterday?
My lord, it was filed on Friday.
Yes,
The date was today, my lord. It's not in the list today, my lord. Kindly.
Oh, God.
Next Tuesday it will appear. Give notice to all the respondents. Urgent motion. Give the number.
Sir, would it be a lordship pleasure to if the matter appears on Monday? with the matter instead of Tuesday? Could it be Monday, my lord?
Like say today is Wednesday and you are required to serve to Thursday,
Lord,
Friday,
we have
Sunday
served.
are
We
holidays.
served. Service is complete. Service is complete.
All right, then Monday.
Grateful, deeply obliged.
Your Lordship, this is the restoration application, Your Lordship.
You want inclusion?
Your Lordship.
The court
Your
is
Lordship,
not neither including nor upgrading
Your Lordship,
matter.
kindly keep it in my monthly list of November, Your Lordship. I don't have any.
Please come on in November.
My lord, this
Yes, please.
My lord, this is an extreme urgent matter. There is twofold urgency. First of all, that my money, I am starving, my lord. My money is falsed, and I got a due process of law. I got an order for return back from the money from different bank account it is holding. If this amount is transferred to some other accused, some other victim, then my money is entire money is gone. I am going to be doing nowhere, my lord. It's a very short matter, just a direction on the banks to transfer the money. It is already the criminal court has given a direction, but there the bank is not the party. Upon the police, it was the direction was there to all the concerned bank to give them notice to return back my money to my bank account. And after that also I have on my own, I also served them the order with the my bank account details and all. But there also the order is not passed, my lord. My 10 lakh rupees is gone. I am nowhere, my lord. Because of my 19-year-old child, entire my money is gone. I am nowhere, my lord. Just a small order, the identical matter I have done earlier before my lord Justice Shampa Sarkar, where it was the bank came and said that they have given the money to someone else. After 4 or 5 months, they will come and say that they got another order for another court and the money is transferred to that account.
Very well. Tuesday it will appear. Serve notice. Yes.
My lord, leave matters, my lord. The petitioners are learned advocates, my lord. They are senior citizens. My lord, the advocates were practicing in Diamond Harbour Court, my lord. And my lord, their fees is not, they are not getting their fees, my lord.
From
My lord,
whom?
from my lord, the government. They were
Government panel advocate.
panel advocates, my lord.
Yes.
My lord, they are in extreme financial crisis, my lord. And my
And
lord,
since when the payment is not being made?
my lord, they are in panel from 2011 and 2012, my lord, and the amounts are more than 10 lakhs and another, my lord, more than
Civil or
7
criminal?
lakhs. My lord,
Civil panel or
criminal panel.
criminal panel?
Yes, my lord.
All right. Tuesday it will appear. Leave.
Grateful, my lord.
How many are there?
My lord, two petitions and two petitioners, my
All
lord.
right. Give.
May I see
Serve notice.
My lord.
May I have your lordship's kindly to mention one matter, my lord?
one matter, lordship? Leave is required for filing of this matter. Urgency is that a notice under section 14 of SERVICE has been pasted on me on my wall, my lord, citing that this property has to be vacated by any day from today onwards. What has happened, my lord? I purchased the property in an auction in 2023. Since then, I'm there. I was neither part of this parallel proceeding in which this has been order has been passed.
You are the auction purchaser.
Lord, I'm in possession, lordship. Kindly take it up, because from today or tomorrow, any day this can be vacated.
But the taking up will not help you because the court is not going to interfere.
My lord, the only thing is that some protection, then I can approach the tribunal.
You immediately rush to the tribunal.
My lord,
That is the only way that
but
can save you.
because the date is given today,
So
and
what?
my lord,
Today it
kindly
is here.
it's very difficult to do this tribunal on the very big.
Yeah, I am aware of the difficulties in filing matters
Kindly
before
take
the
it up,
tribunal, but then I cannot help. That is the only forum.
Only for 2-3 days. If your lordship protects, then I can go and approach the tribunal. It's very unfortunate affairs that I did not know about the parallel proceedings which was going on. The
Very well.
same DM.
Monday it will appear. Serve notice.
Under compelling circumstances.
But urgent application could it be listed?
Urgent application means?
Can
For what?
your lordship's order was not being complied with, filed a contempt application. That was dismissed for deposit.
Sorry. Yes.
Sir, may I have your lordship's kind leave to mention one matter, my lord?
About the deposit with the state commission. My lord, unless the stay order is granted, my lord, this one will withdraw the amount.
I didn't get it.
My lord, we have a claim with the insurance company has repudiated my claim.
Yes.
State commission. And state commission has allowed my application and directed the respondent to deposit the amount. From that, state commission has preferred an appeal to the national commission.
Yes.
And certified the order.
Right.
Now the amount is deposited with the state commission. Now the respondent will withdraw that amount.
Obviously, if the National Commission has not accepted your claim, then what can be done?
Order of National Commission. This-
Before this,
Before this.
all right. Where is the matter?
Item number 1291.
1291, Tuesday it will appear as urgent motion. Serve notice upon all the parties.
My lord, may I have your lordship's kind leave to mention one matter, my lord?
My lord,
Lord, may I have?
My lord, this matter has been filed after obtaining leave from your lordship, and your lordship directed to reappear on 20th August 2075 with a notice from the wetland authority. My lord, after serving notice, my lord, immediately officer in charge Mohasala Police Station issued notice to restoring its own position. In spite of specific notice, my lord, given on 18th August 2025, my lord, respondent number, my lord, extra malar second floor malar already look thalai malar day before you started malar with notice malar I am mentioning to the wetland authority as well as malar the respondent number 8 here
Item number
119 of your lordship's monthly list.
119, Tuesday it will appear urgent motion. Serve notice. It is not required. Slip is not required.
May it please your ladyship. Your ladyship, may I crave leave to mention a matter which was listed before your ladyship on 22nd of July. 4 weeks time was given for the opposite party to file reply. 4 week has expired. They have not filed reply. A liberty
Wait.
was given to mention.
Yes, give. It will appear as to be mentioned. Serve notice upon the other side.
I am mentioning upon notice.
Matter will appear. Please intimate. Tuesday it will appear to be mentioned.
Much obliged. Much obliged, your
Under
ladyship.
compelling circumstances, my lord, I'm mentioning this matter, my lord. Section 14 order passed by the DM. My lord, the police is on this way, my lord, to take possession of a running hospital which has 100 patients. We move before the DRT. The DRT refuses.
Who are you?
My lord, I am the borrower. And the order which has been passed, my lord, declaring me as a borrower is in gross violation of the order passed by the Honorable Supreme Court. My lord,
Did you not
moved-
approach the
moved
tribunal?
before the DRT. The DRT refused to, my lord, interfering, saying that we do not have time. We are keeping this in. We'll decide it at the time when the final application is taken up, my lord. Lord, I have annexed all those orders in
In
my
the
writ
meantime,
petition.
DRAT is also functional.
But will, my lord, I'll have to, my lord,
And,
unnecessarily, my lord, put
no,
in a
sorry.
deposit of 75%. My lord,
Yes,
kindly
this
consider.
is what you are a running hospital. You've got 100 patients. Please deposit the money and get it heard before the 80.
My lord, may I be permitted to, my lord, may I seek leave of your lordships to file it on an urgent basis? Urgency is that, my lord, 10 petitioners are before your lordship who are the owner of at least, my lord, 14 vehicles. The concerned RTO blocked those vehicles and parked in a private parking, saying that I have violated rules regulation. My lord, repeated on asking notice, nothing has been served. On 14th August, my lord, I have getting a my lord message from in my WhatsApp in my registered mobile number stating that I have a fine. I deposited the fine, the challan amount.
Everything is happening within the Motor Vehicles Act.
My lord, that I don't know because when
Obviously,
my
the
lord, when
RTO is taking steps. You are paying fine under the Motor Vehicles Act.
what has happened,
Why
my
don't you
lord,
go
when
before
I'm
the Group
going-
7 bench?
When I'm going RTO is saying that pursuant to BLRO direction, we did that. When we are
BLRO will say
because,
to
my
log
lord,
the vehicles.
according to the RTO, we are carrying.
Go
my lord,
before the
some-
Group 7 bench, please.
Well,
What happened?
item number 56 of today's list, my lord. I made an application or intervention. In that matter, application is appearing. The only urgency is that, my lord, this is a case where on behest of our organization, the complaint is being entertained by the SDO for the purpose of cancellation of the original SC certificate. My lord, what is happening now? The proceeding is going on, and the petitioner has filed this petition before this court after 10 years, where he is claiming that return the certificate, and that matter is pending. And taking this aid when the proceeding is going on, they are citing that it is pending before the High Court. The SDO is not passing the final order. That is the problem which is happening. Item number 56, my lord. I just want
Let us see. I will.
My lord,
My lord, with the-
no focus, my lord, my learned colleague mentioned, my lord, the urgency, my lord, this notice has been issued by the executive engineer of the, my lord, Department of Urban Development, not the Bidhannagar Municipal
It
Corporation.
was submitted. It was the Bidhannagar Municipal
That
Corporation.
was, my lord, that was.
Yes. Urban Development.
Urban Development, my lord, we
Yes.
seek, my lord, implementation of the Street Vendors Act, my lord.
You seek implementation.
I seek implementation of the act so that, my lord, I am not evicted without implementation of the Street Vendors Act, my lord.
Yes.
My lord, they have the urban development is issuing a notice, my lord, directing terming us as encroachers, my lord, directing us to remove ourselves and our vending, my lord, articles. My lord, we say that we have been recognized by the Bidhannagar Municipal Corporation as, my lord, bona fide hawkers, bona fide street vendors. We have
Do you
documents in that
still
regard.
think that it will be under the Group 9 and not under the Group 5 determination?
My lord,
You have moved this type of matters when this bench was taking up Group 5 matters.
my lord, but the difficulty is, my lord, the notice that I am assailing is, my lord, issued by the Urban Development Department. The Bidhannagar Municipal Corporation, my lord, has to be, my lord, directed by your lordship, my lord, and implementation of the act, if your lordship may kindly consider whether it will be, my lord, under Group 9. That your lordship.
All right, Tuesday it will appear as
I'm
urgent
grateful.
motion.
I'm
Serve
grateful.
notice.
May I have
Your Lordship, kind leave that to take leave in filing and moving this matter. Lordship, recollect on 25th of August, Lordship disposed of a writ petition inter alia directing, my lord, the authorities to consider the right of the petitioner to participate in the tender, my lord. They have passed a recent order denying the right of the petitioner to participate in tender, my lord. We are challenging the recent order, my lord. The last date they have extended, my lord. Last date now is the 12th September, my lord. Your Lordship permits me to come back on any day before 12th, my lord.
9th.
So okay.
my lord, may I have your lordship kind leave to mention one matter, my lord? My lord, may I have your lordship to mention one matter with regard to item number 112 of today's list, my lord. My lord, an eviction order had passed by the executive on 8th August, and it has been conveyed, my lord, on 20th August. And immediately I filed an application, my lord, writ application, which is appearing, my lord. By an executive order, my lord, I have been directed to be evicted from my shop room, which is running on since 2015. And my lord, civil proceeding is pending, criminal proceeding is pending, my lord.
Item number?
112, my lord.
Today's list?
Today's list, my lord.
All right, tomorrow it will be upgraded. You serve notice.
Deplorable, my lord.
My lord, I am paying for kind leave. My lord, the husband of the petitioner is suffering with a kidney problem where his both kidney are damaged. At that point, the donor is ready, but the concerned authority did not give the
Yesterday
permission.
this matter was mentioned
Yes, my lord.
and the court refused it, isn't it?
My lord, may I permit, my lord, the petitioner husband is die and true situation, my lord. Kindly allow the respondent authority to give the direction, my lord.
All right, Monday it will appear. Serve.
My lord, may I be
Grateful, my
permitted to mention a matter, my lord, wherein the petitioner is a learned advocate of the Contractor Subdivisional Court, and my lord, he has been selected to for the purpose of acting as a notary, my lord, upon compliance of all formalities. And but my lord, even after deposition of the prescribed fees in the year 2023, my lord, the concerned authority has not issued the certificate of practice, my till date.
Where is the matter?
My lord, matter is monthly list of my lord, item number 1256. Before
1256, Wednesday it will appear. Wednesday it will appear. Serve notice upon all the parties. Yes.
I mean,
May it please your lordship. That I am appearing on behalf of the petitioner. The dispute, my lord, arises between the parties from an insurance claim, where your lordship, my lord, was pleased to direct the insurance company to release those documents which they had relied on to repudiate my claim. My lord, we have received all the documents. We have checked them. It appears to be the documents which we had enlisted in our
The writ petition is
both the
purpose is served.
Yes, and
Please come.
the two separate orders be passed, my
Yes, yes. Which items? 1 and 2.
1 and 2.
All right.
Items number 1 and 2.
Learned
The-
advocate
In 2,
represent.
my lord, we have already supplied the documents. This is the receipt which
Right.
the
Learned advocate representing the petitioner submits upon instruction that the grievance of the petitioners have been redressed. Grievances of the petitioners have been redressed. Stop. Next. In view of the aforesaid submission, there is no requirement of proceeding with the writ petition any further. Stop. The writ petition stands disposed of. Same order will go down in item number 2. Add one line. The written instruction provided by the respondent authority, dated, check up the date, be written with the records.
29th of August.
Disposed. 29th August. Date is 29th August. Disposed. Yes.
Deeply obliged.
I appear for the petitioner. Lordship, in this matter, Lordship, the respondent authorities had filed a report. Lordship, we were supposed to file an exception. Lordship, number 1, we are seeking extension to file that exception. Number 2, my lord, in this report, Lordship, they have taken the point about revocation act which has come with respect to this is the incentive matter.
This is the incentive matter.
Lordship. And that proceeding, there is a proceeding with respect to the same company which is pending before the division bench, my lord. That is coming up on 9th.
9th of this month. 9th of this month. All right.
Lord, I was praying that this writ petition may be taken up after 9th, my lord, so that the stand of the Advocate General be clear.
The incentive matter has
What she
been
was hearing
fixed on
that
the
matter-
7th of November.
25th
that is the
25th
challenge
September,
to the
your
act.
has picked one matter where the incentive, this act
25th
itself
of
is
September.
September. That is my WPO 602.
26th, we are breaking for vacation, and 25th is
No, your lordship has fixed it. I'm sorry, madam.
7th of November.
With affidavits by 26.
Yes. Please come.
Well, I was to praise the report.
That is with respect to another writ petition, though.
Yes, this
There the act is in
scheme,
challenge.
this act is in challenge. Now the scheme is
Otherwise, this
elevated
writ
to
petition
the
has become
state of the
academic.
act. Actually, good. This matter relates to grant of incentive stuff. The provisions of the revocation of West Bengal incentive schemes and obligations in the nature of grant and incentives Act, 2025. Has been fixed for hearing on 7th November 2025. Stop. Let this matter appear in the list on
Lordship, here, my lord, the issue is
7th.
with respect to something else, my lord.
It will
That
be
is why
open
it is being
academic,
heard
my lord.
before that.
Petitioners to file exception to the report filed by the respondents. Stop. Number 2. The report of the Director of Industries dated 22nd August 2025 be written with the records.
Mr. Adok may have come with another report.
No.
Oh,
How are you?
it's a different.
We are grateful, Milord.
I am appearing on behalf of the WBIDC, Malad.
The matter will be listed, Milord.
7th.
We are
In the
grateful.
meantime, you can file an exception.
Hold on.
My lord, I have a writ petitioner, my lord. My lord, I'm praying for a short passover, my lord, because learned senior counsel, Mr. Ratnanko Banerjee, sir, is leading. He had started his arguments, my lord. This is this matter regarding surrender of the RBI license, which was rejected. So we have served notice on the
NBFC.
Yes, my lord.
Today, appear for the RBI.
RBI?
Yes, ma'am.
Nobody was there on the other day. It is your action that is under challenge.
my lord.
What is your submission?
My lord, my submission is, my lord, that in terms of the master circular,
Yes.
it specifies that if any entity has financial income greater than 50% of gross income and financial assets greater than 50% of total assets, then they will be treated as an NBFC and registration with the RBI would be mandatory. My lord, they've annexed a document which is a CA's report at page 123, my lord, which would clearly make it evident that the petitioner's gross income, financial income was greater than 90% and total and financial assets.
Thing is, they do not want to function as NBFC now.
But my lord, the master direction is very clear that if the income is greater than 50%, they will be treated as an NBFC. My lord, may I show your lordship that?
No, you show me what is the provision for withdrawing such certificate, cancellation of such certificate, anything of that sort. Because the petitioner does not want to run the business of NBFC.
My lord, one of the measures can be that if they sell off their total assets and put the entire amount in cash, my lord, that would not be generating any financial income. Hence, the financial income as a percentage to the total income would become minuscule. So they will no longer be a financial entity. They will no longer be treated as an NBFC. Similarly, if they sell off all the assets which are in instruments which they have themselves pleaded, they are in financial securities, mutual funds. So, my lord, if they sell off those investments and put the entire amount in a bank deposit, their financial income as a percentage of total income would be nowhere around 50%. So that would solve their purpose. They would no longer be deemed as an NBFC within the meaning of the master direction.
You come up with a written note so that they can also go through it and come back.
Lord, in that case, will it be your lordship's pleasure to grant me an opportunity of filing an affidavit? Lord, should I come back with a short note on
Vote
this
on
point?
the matter.
Report by way of affidavit. Let somebody take the responsibility. You do not take responsibility on your shoulder. Please come.
And only humble prayer is a short direction before. This is a short point. We also want to.
What will you do with the money? You tell me. You were an NBFC.
Yes.
Now what will you do with that money?
No, that's why we want to surrender and finish it up.
That is what he's saying. That you can surrender it and then you will not be treated as an NBFC.
But the ground of rejection, let them file an affidavit, my lord. Let the ground of rejection is not that.
My lord, the ground of rejection is that, my lord,
My lord, once they show.
Wow, which volume is it?
Yes, my lord. 70 page. Yes, my lord. Volume.
My lord, it is in volume 2, page 160.
My lord, the rejection is at
But
page...
I'm assisting Mr. Dutt.
All right, 160.
Yeah. My lord, kindly comes to the email, page 160 at the end, my lord.
Yes.
Please refer to your application.
Voluntary cancellation.
Yes.
What is the provision for cancellation? This the RBI will just indicate. Please come. Heard learned advocate representing the petitioner and the Reserve Bank of India. Stop. The petitioner seeks voluntary cancellation of the certificate of registration as non-banking financial company. Stop. Learned advocate, not learned advocate. The Reserve Bank of India is directed to file a short report by way of affidavit disclosing the provision relating to voluntary cancellation of the certificate of registration. Such affidavit shall be prepared and circulated by 16th September. Release the matter on 18th of September.
I would request for a week's extension, my lord.
We are approaching the vacation. If you can do it early.
No coercive steps are being taken as
it's not a matter of coercive step.
No, my lord.
It is not a matter of coercive step. It is a matter of disposing of the writ petition. 2 weeks time. It's a short report. Only disclose this provision.
But I want to avoid the embarrassment of coming back and asking for an extension.
So then
19th of September, will it be all right?
Yes, 19th is a
23rd, it is made returnable. 19th, they'll file the affidavit, and 23rd, it is returnable.
Yes. You have to do anything.
The last week,
Yes.
let's see. I do not
know.
No,
My lord will be very busy. My lord, that's
all right. Next.
my lord, and my lord,
I'm sure, my lord, nothing has been done, so my lord, nothing will be done, my lord. So
That is what he says, and that is the
kindly, my lord, at least record that
more
assurance.
time.
My lord, there is no assurance on my part. My lord, nothing has been done since April. We are in September. My lord.
So, my lord,
I do not know.
my lord,
Yes.
my lord, nothing should be done, my lord, in the meantime, because, my lord,
Let's see. 5.
20, grateful.
My lord, I appear for the Calcutta State Transport Corporation.
I appear, my lord, for the writ petition. The writ petition has been filed, my lord, challenging the termination of my license, which was granted to me for 15 years for operating, my lord, an auto LPG dispenser unit at Howrah Depot. My lord, the tender was floated as far back as in the year 2012. My lord, pursuant to the tender, my lord,
Any reason for cancellation, termination?
The termination, my lord, the reason given was there was apparently an inspection done by the authorities, and pursuant to inspection, they found certain vehicles to be parked. And the authorities were of the view that this was not being used as an LPG dispenser unit, but is used for parking purposes. We were given a show cause. We gave a reply to the show cause also. In our reply, we said that we had engaged another agency to operate it on our behalf because there was no bar in respect of that. Now that agency had allowed certain vehicles to be parked there, so we had deprecated that agency. You stopped that practice, and then thereafter it was stopped. So those parking of vehicles were not being allowed to be parked. Now we gave that reply to the show cause. The very next day, the termination comes saying that you have not given an elaborate reply to the show cause notice. Therefore, we are cancelling it. And then what followed was that there was disconnection of electricity also, which was a subsequent event. That is also one of the challenges. I'll take your lordship, Mala. There are 2 agreements which are there.
No, you show me the impugned order.
Yes, Mala.
Termination.
Yes. May I start with the show cause notice then first?
No, page 47.
Yes.
Cancellation of the agreement.
Yes. Mala, that is the
8th of August.
8th of August 2025.
Whose land is this?
Well, this is the WBSTC, then CSTC, then transport.
It is not your land.
No. It is within the depot.
Within the depot. It's the land of the authority.
Land of the authority, 8,000 square feet of area. I was allowed, my lord, to operate LPG auto LPG dispenser.
But why will the writ petition be entertained, will you say? You all have a contract between you all. There is an agreement. There has been
Page 36 is the license agreement. 2 agreements were executed. One is the license.
But why will the writ petition be entertained?
May I try to satisfy your lordship on this point?
In terms of the license agreement, the license has been done.
Is there any dispute resolution clause in the agreement?
There is, my lord. May I, my lord? There is a dispute resolution clause. I'll address your lordship. Now, my lord, may I indicate, my lord, may I try, my lord, try to satisfy your lordship as to why the writ will be maintainable. Complete arbitrariness in state action.
Arbitration to the chairman of the licensor.
Now, first and foremost, my lord, the arbitration, that chairman part, my lord knows now this law has been the alteration of the Arbitration Act, my lord, that will go to an independent arbitrator, but I'm not really on that. My lord, complete arbitrariness in state action, my lord, may I indicate how? There are 2 agreements. My lord,
the court is not going to look into all these things now.
My lord, kindly, my lord, looks at the show cause notice, my reply, and then, my lord, the cancellation. Then if my lord feels, my lord, I'll be out of court.
In that case, let them file their opposition.
Well, in the meantime, let the coercive steps be taken.
No, sorry. Please come.
Well, may I kindly seize the show cause notice.
Petitioner is aggrieved by the cancellation of agreement within bracket deed of license dated 8th August 2025 issued by the managing director, West Bengal Transport Corporation. Stuff. According to the petitioners, the cancellation has been made contrary to the provisions of law. Stop paragraph. Learned advocate representing the state respondents.
I am for the state.
I am
for the CST.
Respondent number 1, state, raises a preliminary objection.
But I am also raising it.
Acha, learned advocate representing the respondents raise a preliminary objection. With regard to the maintainability of the writ petition before this court. Stuff paragraph. The respondents are directed to file their affidavit in opposition within a period of 1 week after reopening of the court. After the ensuing Puja vacation, reply, if any, be filed within 10 days thereafter. list immediately on completion of the aforesaid
Let no
period.
further coercive measure be taken, my lord. My electricity has been disconnected also. Let no further coercive measure be taken. Otherwise, the writ becomes infructuous. My lord only records my prayer, my lord, and then
Writ will not become infructuous because if the court ultimately finds that the cancellation is bad, you'll get back everything.
My lord, my lord, make it subject to
Next.
everything to be subject to the outcome of the writ petition. My lord, kindly
Word
records that.
without saying.
My lord, kindly.
Provision of list
Kindly,
maintenance is
kindly
there.
adds-
No.
adds one line, my lord.
Unnecessary words not to be put in the order. Yes, 6.
Deeply.
Grateful.
Yes.
Lord, we made a complaint before the CAB, my lord, the Cricket Association of Bengal. In short, my lord, the rules say that
Yesterday another CAB matter was there.
Yes,
This is
my lord,
separate.
I've seen the order, my lord. This is the lordship upheld maintainability of writ petitions, and then, my lord, we didn't go into it further. My lord, because it's a different matter. Now, my lord, under Rule 70 for grievance redressal, when a complaint is received by CAB, my lord, it is supposed to, my lord, go to the Apex Council. Apex Council is a conduit. It sends it to the, my lord, chairperson for CEO for, my lord, an inquiry. Inquiry report goes to Apex Council. Apex Council sends it to the Ombudsman. The learned Ombudsman decides the matter, whether to drop it or whether to proceed. Net effect, this is as per Rule 70. Net effect is, my lord, the Apex Council has no jurisdiction to decide anything, neither does the CEO. It's, my lord, with the learned Ombudsman. Now, I made a complaint, which is
Who
that...
are you?
My lord, I am, my lord, yes, I am, my lord, the complainant is, my lord, are members of Wari Club, which is a constituent of, my lord, CAB. One of the clubs under CAB, there's a, my lord, long fight with, my lord, the treasurer. We have filed, my lord, a proceeding before the learned ethics officer, which is, my lord, a separate matter. There, my lord, hearing is concluded, judgment is, my lord, awaited. There, my lord, the only issue before the learned ethics officer is conflict of interest. When, no, please.
Let me take the preliminary point. I will visit then.
Maintainability.
This is an inter-state dispute between my member and
Who
my.
are you?
I am the Wadi Club.
No, no, he's, my lord, there is nobody. Lord, there is a...
Allegation is against me.
Allegation against you. Where is the club? Club is the party.
Club is not a party.
I am the treasurer of the Wadi Club, a general secretary of
He's
the Wadi
not a
Club.
party.
19. I am a party.
আমি জানি না বলছে ওয়ারি ক্লাব হি ইজ নট
Provision of
অথরাইজড টু
duty.
রিপ্রেজেন্ট ওয়ারি
Allegation against me. Suit has been filed.
Miller, they don't want...
For honorable judge of this court has been appointed to look to the affairs of the Wadi Club. This is continuing with this. In these circumstances, writ petition according to me is not maintained.
But I just not add one sentence. Lord, apart from the internal dispute, there is a suit filed in the city civil court. And Lord, that matter traveled to the division bench of our Honorable High Court, where Lord, a learned judge, a retired judge, has been appointed as the chairman. The board has been superseded. Elections have been directed to be held of the club.
The Wari Club.
Wari Club.
All right.
And Lord, also there is a direction that Lord, there has to be a special audit conducted. The order.
11th of August.
Yes, Lord. Kindly have a look at that.
25 years.
So, Lord, this fact has not been mentioned in the writ petition.
And were the petitioners aware of this fact?
Because some of them are parties to the.
All right.
Kindly see paragraph 8 onwards.
Yes.
Your lordships will find, Lord, the directions.
Right. So why don't you raise all issues before the...
Lord, may I just say this? My learned seniors, my lord, do not want me to place the subject matter of the writ petition.
No, if the subject
This is
matter...
absolutely
Your
unconnected.
subject matter is there in the writ. They are aware of what is there in the governments you've made in the writ. And they raise a preliminary objection with regard to the maintainability. The order of the division bench has been placed. What more?
My lord, may I answer, my lord? May I show your lordship the subject matter and answer, my lord, these objections?
Yes.
My lord, my learned friends say that these are, my lord, matters concerning Wari Club, which, my lord, are subject matter of a suit. But I am not here before your lordship regarding, my lord, subject matter of Wari Club. Wari Club is, my lord, not the subject matter of this writ petition before your lordship. Absolutely not. What is subject matter? I am a member of Wari Club, and I have made a complaint before the CAB. When I make a complaint before the CAB, I make it about the private respondent, the respondent number 19. He is, my lord, the treasurer of the CAB, and he was also an office bearer of Wari Club. What is my allegation in the complaint? I have, my lord, two complaints. One subject matter of this writ petition, one not subject matter of this writ petition. The one which is not subject matter of this writ petition, which I have already argued before the ethics officer, is no man can hold two posts, one in CAB as treasurer and one in another affiliate club. That's, my lord, judgment awaited. We are not there. Second is, I have filed a complaint saying the treasurer is holding post of CAB. Treasurer is also responsible for seeing accounts of all these clubs, because CAB gives these clubs money and CAB sees the justification of money spent. So money being given to Wari Club and money, my lord, justification of money spent is to be seen by the treasurer. He has, through Wari Club, siphoned away a lot of money of CAB. I, my lord, as an affiliate of a member club, I am entitled to make a complaint. Now that complaint, my lord, has to be decided by the ombudsman. But it is not permitted to reach the ombudsman by the Apex Council, acting without jurisdiction. That is the subject matter. This can't be decided in a suit. My lord, please, may I show your lordship, my lord, regulation 70. My lord, please come to page 173. This has nothing to do with Wari Club. But please see the rule.
You have problem with the accounts?
No.
What?
In the writ petition before your lordship,
yes,
I have problem with the respondent number 19 functioning as the treasurer of CAB. That cannot be decided in any suit.
This issue you say is pending, is awaiting order from some authority?
No. No.
Two matters.
Two matters. That is, no, that is a separate matter. That is ethics of jurisdiction under, may I please take the rules? I'll explain in 1 minute. Page 173.
Yes.
Regulation 69. And the previous regulation 68. That's at 171.
Yes.
This is such an impossible situation for the CAB. They don't want me to enter. Please see 171.
Yes.
Regulation 68, this is ethics officer.
Hmm.
The association shall appoint an ethics officer at the annual general meeting for the purpose of guidance and resolution in instances of conflict of interest. So that's the entire jurisdiction of the ethics officer. Conflict of interest. This is, my lord, going on before, my lord, the ethics officer. Now, my lord, please come to page 173.
What is the issue before the ethics officer?
Conflict of interest.
Yes. How the conflict arises?
Conflict arises simply when you are an office bearer of Wari Club. Can you be elected as the treasurer of CAB? That's all.
Right. This is there before the ethics
Yes. Now,
officer.
I have appeared before, my lord, the ethics
Whatever.
officer.
Right.
The only argument which you are permitted to make before the ethics officer is whether, my lord, this is possible. Can you be a treasurer of CAB and also an office bearer of Wari? And is it, my lord, they said that no.
Right. Now,
Lord,
what
may I
is the
just-
challenge here?
Yes, may I just one more sentence? They came and said you cannot. I said that no, this is an intractable thing. You must proceed. And that's being decided by the ethics
Right.
officer. Now, my lord, please see 173. The ombudsman. All problems, my lord, go to the ombudsman as per Lodha Committee's report and the Supreme Court judgment. My lord, please see 69(1). The association shall appoint an ombudsman at the annual general meeting for the purpose of providing an independent dispute resolution mechanism. The ombudsman shall be a retired chief justice of a high court so appointed by the association after obtaining his or her consent on terms as determined by the association in keeping with the dignity and stature of the office. Now, my lord, please see 70, grievance redressal. And my lord, come down to my lord, C, which is at the bottom of 174. Misconduct or breach by others. In the event of any complaint being received from any quarter or based on any report published or circulated or on its own motion of any act of indiscipline or misconduct, indiscipline, misconduct, violation of any of the rules and regulations by any player, umpire, team official, selector, or any person associated with the association. The Apex Council shall refer the same within 48 hours to the CEO to make a preliminary inquiry. Then, my lord, please see 175 procedure. The CEO shall forthwith make a preliminary inquiry and call for explanations from the concerned persons and submit his report to the Apex Council not later than 15 days from the date of reference being made by the Apex Council. On receipt of the report, the Apex Council shall forward the same to the Ombudsman, who shall call for all particulars, and unless it decides that there is no prima facie case and accordingly drops the charge, hearing shall commence. Now, my lord, in this case, I make a complaint, which is at page 184, about, my lord, misconduct of the treasurer, saying two things, essentially. Number one, you are as treasurer pumping in money using, my lord, Wari Club as a conduit to, my lord, channelize the money to yourself. And I gave proof with bank statements. Number two, when, my lord, justification comes from Wari Club, you don't, you fudge it up and you don't, my lord, let others know. Now, this complaint, the, my lord, Apex Council doesn't send to the CEO. The Apex Council closes the complaint. My lord, as per the rules, Apex Council must give it to the CEO. CEO will do preliminary inquiry, submit report to Apex Council. Apex Council will give to Ombudsman. Whether to close it or to proceed is jurisdiction of Ombudsman. But Apex Council doesn't do any of it. It acts without jurisdiction in closing the report. And not only that, we bring it to the notice of the Ombudsman. The Ombudsman refers it to the Apex Council for, my lord, inquiry, etc. Apex Council, my lord, doesn't send it back to the Ombudsman. Please, my lord, just one document I'll show your lordship, completely without jurisdiction. Please see page 357. My lord, 357. This has nothing to do with Wari Club.
Where is 357? There is only 356 page.
No, this is
351.
350. I'm sorry, my lord, 351.
Yes.
351. So very sorry, my lord.
Huh.
My lord, first is number 5 on the members present, Mr. Probir Chakraborty, Honorable Treasurer. So he decides, he's a judge in his own cause. Now, my lord, please come to the last paragraph. Mr. Amolendu Biswas expressed the same sentiment that if the Apex Council were to go into complaints against its own members, there would be disharmony and discord. According to him, the Constitution empowered the Honorable Ombudsman and the Honorable Ethics Officer to take up such tasks, and it would be in the interest of all concerned that the Honorable Ombudsman and the Ethics Officer do the needful in the matter, rather than the Apex Council entering into issues of conflict. He's right. Now, my lord, please see. President took up the agenda and invited Shri Sen to brief the members on the issues to be taken up for consideration as per the 6 items of the agenda. Shri Sen at the outset submitted. Please come to the last, my lord, 2 lines. The Apex Council may issue a show cause notice calling for explanation, and thereafter it is the Apex Council which is to refer the same to the Honorable Ombudsman. My lord, Apex Council is, my lord, nobody to do all this. Then, my lord, as such...
Prior to moving further, please show me the judgment that you are relying upon, where the inter se dispute between the members of the club can be looked into in a writ petition. Please show me.
This is not an interstate dispute between.
What is it?
Between members of a club.
Between two clubs?
This
I'm
is
speaking private
not-
dispute.
This is no. This is a matter. Milord, CAB, under CAB are, Milord, its constituent clubs.
Yes.
Now, Milord, we are all members of constituent clubs. My complaint, I have an interest, Milord, through the club in CAB. Otherwise, Milord, now, Milord, kindly see Rule 70. It is so wide that I am entitled to make a complaint. Now,
You make a complaint. Why come before the writ court? Whatever the forum is.
So I've made a complaint to the ombudsman.
And you come to the writ court. Why?
No, no.
How is the writ maintainable?
Your lordship will kindly see, Milord, the decision of the ombudsman here.
I will not look at the decision. You show me that the writ
No,
is
please,
maintainable.
Milord, please, just one, Milord. Please see page 317. The ombudsman says place it before Apex Council because
Whatever, please show me that the writ is maintainable.
Milord, I'll show your lordship, Milord. Please come to page 317. Milord, I have no other way, Milord, forward. He's closed the complaint. Milord, please see page 317.
Yes.
Let the complaint of Parthopratim Shannal and 5 others dated 30th May and complaint of Devashish Bhattacharya and 43 others dated such and such addressed to President CAB and members of Apex Council be treated as complaint submitted before Apex Council, which may be disposed and who may dispose of the same by following provision contained in Rule 71C of the Memorandum and Rules of the CAB or any other rule which may be found applicable. The complaints may be placed before Apex Council. So all these 45 complaints, Ombudsman says, treated under regulations Rule 71C and this by the Apex Council. Rule 71C says.
Why will the court look into this? You please show me the
Milord,
power of the writ court to enter into and decide this.
Yes, so Milord, power of the writ court. Milord, please see what's Milord today. If CAB acts contrary to the rules, I have gone to the Ombudsman. Ombudsman has sent it to Milord the Apex Council for the purpose of sending it to the CEO for inquiry. Apex Council doesn't send it to CEO for inquiry. Apex Council dismisses it. Now, where will I go?
It will come to the writ court.
I have to come to
Anywhere anything happens, the writ court is the only forum where you can come. Sorry, sir.
Milord, so Milord, unless Milord, may I just say this? Unless I go, Milord, if the secretary, if the Apex Council of the CAB doesn't, Milord, act in terms of the rules, I have nowhere else to go but the writ court.
No, very well.
Milord, your lordship's order yesterday, Milord, says so.
Yes.
No,
Yes.
has been kept open.
Right.
Milord,
The court has not gone into Article 12 association is all right to a particular limit. Not in this context.
Milord, where is
not in this context?
Milord, the context? Milord, your lordship must see the context. Then may I
have
show
got it. You have made submission. Even thereafter, I do not find there is any public law element involved. It's absolutely between the members, inter-se clubs, and all private disputes. Nothing
Milord,
to do.
Private, then see the Milord. I haven't even shown your lordship the complaint. I'll take 2 minutes for the complaint.
I don't think so. I'll entertain.
Very well.
You better go up to the
Let us
division
come
bench
back.
and see. And
come back
the petitioners claim to be executive members of the WARI, W-A-R-I, Athletic Club. They raise certain allegations against the respondent number 19.
Milord, may I just say one sentence?
Yes.
If your lordship permits me. Milord, in this situation, I can either come before your lordship or I can go before the ombudsman. Milord,
I will not mention where to go. It is up to you.
So I've come before your lordship.
I am not entertaining. Now where you'll go,
It's
you
up
will
to
advise your clients and you have to find out. But then the writ court will not enter.
Very well.
There is certain allegations against the respondent number 19.
Respondent number 19, who is an office bearer of the
We will go to you.
Warri Club as well as the Cricket Association of Bengal. Stop. The petitioners raised allegation against the aforesaid respondent before the ethics committee, ethics officer. Stop. The matter thereafter traveled before the ombudsman, and the ombudsman directed the matter to be decided by the ethics council,
Should be ethics officer.
ethics officer.
Milord, may I? One thing. I'm sorry, Milord. Milord, may I do this, Milord? May I take this before the ombudsman again?
I will not say. It is up to you. You take, you do not take. It is up to you.
Yes.
Check up the laws, how
Milord,
it plays,
actually,
because I don't know.
I feel, Milord, it's maintainable. But, Milord, your lordship
Why
feels
don't you try
otherwise.
it before the division bench?
No, I don't have time.
Ombudsman.
I don't have time, Milord. I'll take it to the ombudsman and take a try.
It is up to
Lordship kindly,
you.
Milord, disposes of the writ, giving me leave to go before the.
No, this
No
leave I cannot give.
Very well. But Milord, if your lordship doesn't, then Milord allows me to withdraw with leave to file. Milord, don't close my doors. I have a valid complaint. Your lordship feels this is not the right forum. Let me try the ombudsman.
I will stop there only. The writ will not be maintainable. I stop there. Thereafter, it is up to you
But
to
if
take
the-
it before
Milord,
the appropriate forum.
Let me, Milord, take another try later. But if your lordship holds today that this is a private dispute and therefore this is not maintainable, I'll never be able to come back to the writ court. Milord, I'm being
You
very
have
honest.
already placed your case. Now, when you see that
No,
you
your
are
lordship,
going
let
to
me-
get any
Milord, I'm one
favorable
of it.
order,
You can let me go. I'm not.
who is fastening you? Nobody is
But if your
fastening you.
lordship
You have
holds that this is a civil dispute,
on the facts that you have placed.
Yes.
This is what is playing in my mind, that this is not a matter to be decided in the writ court.
Milord, let me consider it and come back, Milord, on Monday.
Yes, I think.
Milord, it will completely close all doors for me.
All right, let me record at least whatever is playing through my mind.
Milord, in that case, I'll get into serious trouble. Milord, I request your lordship, Milord. I have a valid case. It's a jurisdictional issue.
The matter thereafter traveled before the ombudsman, and the ombudsman directed the matter to be decided by the ethics officer.
Right. The petitioners are aggrieved by the same and submits that the writ petition will be the only the writ will be the writ court will be the only forum where the matter can be adjudicated. Stop. The learned counsels representing the respondents raise a preliminary objection with regard to the maintainability of the writ petition. Stop. Learned advocate representing the petitioners seeks time to revert Monday.
I'm grateful, Milord. I'll reconsider it if I find a complete answer. Otherwise, I'll go back to the ombudsman. Grateful, Milord. Ma'am, the advantage of ombudsman is I'll get some food. My fish roll cow.
I tell you what happened.
Item number 1, my lord, I am for the respondent, my lord. My lord, paragraph number 6, in the order dated 23rd July 2025, my lord, it should be the court does not find. It's a, my lord, typographical error, my lord.
Yes,
Paragraph 6, my lord.
it is your order. Yes.
May it please your ladyship, has come up at the instance of the matter being mentioned at the behest of my client, my lord. I'm representing the respondent number 3. Where I was praying for my lord, an extension of time, my lord, to file the affidavit in opposition. Just seeking for my lord, an extension of 4 weeks time, my lord.
Where is the petitioner?
We are mentioning my lord upon notice, my lord. In fact, the petitioner also mentioned when we mentioned on the same day.
My lord, I am happy with 1 and 2, my lord. I am also paying time to file opposition. My lord.
You give a call to any of the learned advocates for
No,
the
no, but
petitioner?
we have already served notice also, my lord.
Let me see.
Yes. Notice. They served a notice that they will be mentioning. We also served a notice that we will be mentioning.
To who did you serve this notice?
Rotikanto Pal, my lord, on behalf of the petitioner, served a notice upon my advocate on record. And my advocate on record, my lord, also, my lord, simultaneously served a notice upon Mr. Rotikanto Pal.
This is
In the same trail mail.
interesting. This is Rotikanto Pal's communication. Where is your
The
communication?
trail mail, my lord, at the bottom, my lord.
You have mentioned on first sitting to extend the time. To file the, yes, let somebody remain.
Yes, yes.
There is a prayer for extension of time for filing the opposition.
I cannot stand in that way.
Acha. Time?
But may kindly grant us, my lord, 4 weeks time, my lord.
That will be, my lord, the
No,
point
it's a
is,
continuing process. Why?
my lord, the only point is that the post is.
Whatever the point is, vacation is intervening.
Yes,
So
but we'll
it
give
cannot
us,
be done.
we'll give them 2 weeks, give us 2 weeks.
4 weeks.
After the vacation, we can be ready with the hearing.
But 4 weeks, 2 weeks after vacation.
The prayer of the Learned Senior Counsel representing the respondent number 3.
21st of July.
Learned Advocate representing the Election Commission of India. Time to file the affidavit in opposition is extended till 26th, the last day prior to the vacation.
Oh, my lord, kindly, my lord, 1 day after the vacation, my lord.
From 21st July, 6 weeks were given.
1 day.
Yes, it's long over.
No, no, not long over, but it got over only yesterday, day before yesterday.
Yes, but 6 weeks sufficient time has been given to them.
What is the matter about?
Well, matter is for not declaring the election when a candidate elected candidate has expired in the meantime.
Oh.
And election petition is pending. That is the point of Mr. Bhattacharya.
But I had submitted, my lord, that this is nothing but champati.
Whatever it might be, it can be done in a.
Might be. I'll indicate what it,
6
it
weeks
can be.
given to
You
them
cannot
to indicate
substitute.
everything.
You cannot substitute by submission.
6 weeks are given to
My
indicate
contention
everything.
is, my lord, these
6
are
weeks has
people
been
set up,
wasted.
my lord, by the party in power.
27th
my lord.
October. 27th October. Reply, if any, by 7th of November.
Grateful to you.
Liberty to mention for hearing immediately on conclusion of
Extremely
the
grateful.
aforesaid time period.
Grateful, my lord.
Huh? Nishchoy. Ekdom. When I see it's Pradeep, I do not look at anything else.
My lord, in this matter, I appear for the petitioner on 27th August. Lordship has disposed of this writ petition. The appearances have been wrongly given. That's
All
why
right.
for correct.
What should be the appearance?
My lord, she appeared. Her name is not featuring in.
All right.
And three of us appeared for the petitioner. It is written we appear for the bank.
These 3 names will remain?
Yes, but for the petition. And her name will be inserted for the bank.
All right. Petitioner slip আছে দেখুন।
Yes, my lord. Yes, my lord. Yesterday I filed already.
No, the order sheet is here.
The
It's
order
not
came
required.
in the server. I
ওনার নামটা একটু নিয়ে নাও। Take her name. All right, it will be done. It will be done.
Lordship, I am for the petitioner. For correction, Lordship, in second paragraph, second line, it is submitted that during pendency of the writ petition, appeal has been disposed of. Appeal is pending, Lordship. Petitioner here preferred the writ petition, Lordship, for getting the information under section 6 and challenging this petitioner preferred the appeal. That appeal is pending.
1 minute. Certain information before the response being briefed, prefer an appeal. which is pending consideration.
Yes, it is submitted that during pendency of the writ petition, the appeal has been disposed of. Appeal is pending, Lordship.
Oh, so the first paragraph it
Yes,
mentions that
second
the appeal
paragraph,
is
second line,
second paragraph
point
is
is
wrongly
not
mentioned.
required. Yes, Lordship. Because here petitioner preferred the writ petition, Lordship, for getting the information under section 6. During pendency of the writ petition, petitioner preferred the appeal. Money for information he has got, challenging the information, he has preferred the first appeal, Lordship. That is pending.
That is pending.
Yes, Your Lordship.
And the information you have got.
Yes, Your Lordship.
Acha.
Being aggrieved by the information, petitioner
All
preferred
right,
the
all
appeal.
right. Item paragraph number 2 will be deleted.
Grateful, Lordship. Grateful, Lordship.
Item number 5, my lord, his writ petition has already been disposed of. My lord, the matter has come up before your lordship because the attendance for PMD has not been recorded.
led by Mr.
My lord,
Banerjee.
I appear for the petitioner. I think, my lord, their attendance has gone down wrongly, my lord. EMC was expunged, but Mr. Ghosh's name somehow has gone in there, who was not.
Give your appearance. Give your appearance, please. ওনার appearance record করা হয়নি।
ভালো তো মিস্টার ঘোষের নাম গেছে তো ভালোই তো হয়েছে।
But only you were there or somebody one
Yes, my lord, for
কে আছে দেখি KMD এর জন্য he was not there. He was not there on that day.
Yes, I was personally not there.
KMC already আছে শুধু KMD
KMDA's council's names have not been recorded.
What is your name?
My name is Aditya, but the advocate on record is Mr. Abhishek Guha. So he was there, and Mr. Shishana Bandhavadya leading in the matter, he was also there.
Was he present in
Yes,
court?
because in the order sheet, in para 4, our submission is recorded on behalf of the KMD. He was also present, my lord.
He was present.
He was present.
Give the name of the learned advocates who were present.
Yes.
Give.
আমাদেরটা নেই petitioner
এসে এত দরকার নেই তো it's only his appearance that will be recorded, nothing more.
আমাদেরটা করবে না let our appearance be recorded for today.
Why? No requirement.
There is a requirement before
No requirement. Absolutely no.
there is a requirement
শুধু ওনার নাম দুটো দিয়ে দেবেন।
Grateful, mother.
Yes.
নামগুলো দিয়েছেন
Yes.
My lord, I'm for the petitioner, my lord. The written communication, my lord, I have already handed over at the time of mentioning on last statement.
Stated.
The grievance sought for by the petitioner has already been redressed by the authority during the pendency of the writ petition. Stop. In view of the above, there is no requirement of proceeding with the writ petition any further. The same stands disposed of.
And my lord, the original written communication has already been handed.
Yes, communication is on record. Please note that.
Grateful to you.
Well, for the petition in this matter, my lord. Here, what happened, my lord? My lord, my license of my lord, the nursing home has been kept withheld on the ground that the civil suit is pending and there is an order of status quo in respect of the civil suit. My contention is before your lordships. My nursing home is situated.
Show me the order of the civil court.
Page, my lord, if your lordships kindly come, page 56. Page 56 first, my lord. This is the impugned communication, my lord.
Yes.
Page 59, my lord. Sorry, my lord. 56 and 59. 56. This is the letter issued by the Chief Medical Officer. Please find enclosed such and such, such and such. In this connection, that your application for renewal is license is currently on hold. A license may only be considered after getting opinion from the competent authority. Now, 59, if your lordships kindly come. After getting opinion from the competent authority by note number such and such, this is to inform you that your application for renewal of the license will be held as per order number 62 of 2024 passed by the civil judge. Now, if your lordships kindly come, the order is at page 42.
ordering portion.
Is the state a party over here?
My lord.
In the suit, is the state a
No,
party?
no, it's a private dispute.
Private dispute
My lord,
between you and?
between me and my lord, my partner of my husband, in respect of the different property, no way connected with this property, my lord. Now I will come to that, my lord. The plaintiff and the defendant number such and such hereby directed to maintain status quo in respect of the such and such nature, character, position, Schedule 1 and Schedule 2 suit property more fully mentioned in the schedule of the plain till date such and such, plaintiff complies such and such. This is the, my lord, the first order of 2020. Now it has been further, my lord, clarified, not clarified, this has been confirmed, page, my lord, 49, my lord. No, 46. This order has been, my lord, relied upon by the, my lord, authority. Kindly see. Considering all, I think that the parties of the suit have no right to misuse property such and such, such and such. The order number such and such of 2022, which just now I have shown to you, is hereby made absolute till the disposal of the suit. So, mother order is that, my lord, page 40, my lord, 42. Now,
All right, and
now, if you kindly come, my renewal of license, renewal first, my lord, page 48, if you kindly come. Twice they have renewed my license. This time, they kept withhold on this ground, my lord.
All right, state.
My lord, after inquiry by the COMH, it is revealed that all the hospitals is under same address, like 21 Chaibasha Road, my lord.
So the address may be same.
Wait.
By the COMH.
No, I didn't follow. All the hospitals?
Yes.
All the hospitals means this is only one hospital.
Medical hospitality or the Divjati nursing home.
Page.
No, it's a report by the COMH.
This nursing home, what is the name of this nursing home? Siddharth Medical and Multi-Speciality Hospital. Yes.
By the CMOH, that its address is 21 Chaibasha Road, not 514 Chaibasha Road.
May I clarify, my lord?
No. Let me understand first. Where is the address of the hospital? You have mentioned it anywhere.
My lord, page 48, if you lord kindly come.
48.
This is the first, my lord, time they have granted of 2022.
48.
Of the nursing home.
21 Chaibasha Road.
21 Chaibasha Road. My lord, in my plot is, my lord, 12 katas. This is the newly constructed building apart from, my lord, the suit premises. I will come to that, my lord.
What is the suit premises?
My lord. Now, if
show me the schedule.
Yes. Now, if you lord kindly come, my lord, the schedule, page 41. Schedule 1, my lord.
Where is the address? There is no address.
Page 41, my lord.
41, where is the address?
Yes. Now, this is the, my lord, they have mentioned, my lord, the plaintiff has mentioned. District Purulia, PS Purulia, Moja such and such, plot number such and such, RS Khotin number such and Purulia Municipality, ward number 8, holding number 21, part, measuring number 2730 square feet in the first floor of the building, that is Siddharth Diagnosis Building. My lord, the plot is not Siddharth, my lord. Siddharth Diagnosis Building consisting of 10 rooms and 6 toilets and 1250 square feet in the second floor consisting of 1 room. This is in respect of this property only, my lord, there was a status quo, admittedly. I am not holding any nursing home in this property, my lord. My lord, if you lord kindly see, my lord, if you lord kindly see, my lord, page 80. Well, if it is page...
No, but then you do not disclose anything. You say there is a suit and that is the reason the injunction order is there.
Not only the suit, there is several malpractices.
Where is it mentioned?
In the report.
Your report will not do. Your report cannot extend the order that has been passed. You cannot add in new grounds. Page 46. No, page number 59.
Well, if you lord kindly come, my lord, page 81, my lord. But may I clarify the position? My lord, here I have the 2, my lord, buildings in a, my lord, plot of land. Now, my lord, there is a 12 kathas of land. in my lord 2 katas of land, this building is situated, which my landed friend wanted to say. My building is newly constructed building.
Are you continuing with the hospital?
No,
You
I have
stopped it.
stopped, my lord.
You file a report, disclose everything. Please come.
And my lord, may I, my lord, submit one thing?
The
If your lordship is
application
kindly,
for renewal of license of the petitioner's medical institution has been kept on hold by the Chief Medical Officer of Health, Purulia, by passing order Vide Memo number 1731, dated 11 July 2025. Stop. The learned advocate representing the state respondents submits that there are several illegalities for which the application for renewal has been kept on hold. The Chief Medical Officer of Health, Purulia, is directed to file a report by way of affidavit disclosing the reasons for keeping the renewal of the license of the petitioner on hold.
well, in the meantime, let them, my lord, personally inspect to the property, my lord, because they have not inspected the property, and my lord,
By-
my lord, they are saying, my lord,
by 17th, 2 weeks time granted to you, released on 23rd.
well, in the meantime, let them physically verify the, my lord, property, because this building is separated from the building, because twice.
It will be open for the Chief Medical Officer of Health to conduct a spot inspection
My lord,
to ascertain proper facts.
my lord.
Good. ঠিক আছে, থাক।
The matter will appear on the another same heading, my lord.
Urgent motion, all right, urgent motion.
So I would to appear on behalf of the petitioners, my lord. My lord, it is that matter with regard to the Puja permission, which your lordship was pleased to direct to appear today. But yesterday, the honorable division bench was pleased to take up the matter, and the matter has been adjourned due to paucity of time, and it has been placed coming Monday, my lord. So, my lord, as I submitted, my lord knows, my lord, nothing has come up as of yet.
Yes, please.
And all the parties agreed that the matter be taken up on Monday, because there was a party seeking to intervene in the matter. Now, my lord, on that presumption, I had brought it to the notice of the honorable division bench that this matter is fixed today. So the lordship said that wait, and we are going to hear of the matter and discuss it upon Monday itself. So if your lordship wants me to hold my guns till Monday, your lordship allows me to do so, because if he does not get a opportunity to prove his case, then he will not be able to raise a.
The petitioners are not a party to that writ petition.
They are party. Your
But
lordship,
my learned senior friend will kindly
Your
produce
lordship-
one paper, one document with regard to that
Yes, I will-
submission. That Kollan Shomiti is the club is a party.
Yes, Kulon Sumili, it is. No, it is.
Then the appeal is, who is contesting the appeal?
My lord, what has happened, my lord, there are other writ petitioners who have filed the writ petition. It's a public interest litigation.
All right.
The localites of the particular locality does not want a community hall to come up in place of the children's park. My lord, this
So
is
that's
the
something different.
But the club is not a party there, my lord.
Not club is not a party, but club has sought to intervene in the matter.
Is it?
Yes, and now.
My lord, let there be, my lord will, my lord, my learned senior friend will show one scrap of paper, my lord, to show that. One scrap of paper that the club is before that particular public interest litigation.
Who has intervened?
But one of the parties has intervened.
It's not the club.
Is it the club?
No, they have brought the club. And the photos of the club has been produced for the honorable division.
My lord, the club is not a party, my lord. These are photos of what we do not know.
That's what I'm saying. Let everything be cleared up before the division.
This is a circuitous way to.
1 minute, 1 minute. The issue before the division bench possibly is for construction of a community hall in the open space of the park.
Yes.
In the entirety of the park.
In the park.
Entirely.
Right? Now these petitioners seek puja permission because they were conducting puja for several years.
71 years, my lord.
2 years.
71 years, my lord.
71 years puja?
My lord, 71 years. It's my constitutional petition.
No,
is
no,
constitutional,
listen,
right?
what you are showing are legal documents. The petitioners will not get any right. The conducting of puja will not create any right. What is this? This is a record of rights I can see.
This is a mutation certificate.
Yes.
In the name of the club, showing that the club in ward number 16 has got 3 katas of land.
Yes.
In their own name.
Right.
And they are conducting pujas, prayers, community hall, everything there. Your Lordship can see.
No, no, even if it is admitted.
The issue is on the 22nd, 23rd and 24th, 2023 and 2024. Your Lordship was not posted with the actual facts. On the failure of my clients, I'll say I'll go to that extent. Because before that, for the years 21 and 22, they sought permission from the HDO.
Very well, please come. The issue relates to grant of puja permission in favor of a club which is reported to have conducted the puja at the same place for the last 71 years. Stop. The puja is being conducted in an open park by raising temporary pandal. Stop. A writ petition was filed challenging the construction of a community hall in the park.
With a PIL.
Achha, writ petition,
only.
within bracket
Yeah.
PIL. The said matter is pending consideration. Stop. As the Durga Puja for the year 2025 is approaching, the petitioners obtained permission from the police for performing the puja at the said place, and the said permission has been allowed. Stop. The petitioner presently requires the permission from the Maheshtala municipality. Stop. The municipality contends that as the public interest litigation is pending and scheduled to be taken up for consideration by the court on 8th September 2025, accordingly, the matter may be adjourned for the time being. Stop. Paragraph. On the other hand, learned advocate representing the petitioner submits that as the time for the puja is fast approaching, accordingly, permission may be granted for raising the pandal. Stop. Next. Paragraph. Fact remains that the learned advocate representing the municipality, municipality further submits that the club has land recorded in its name where they are already conducting puja, and accordingly there is no requirement of holding further puja at the place, at the park. Are you conducting any further puja?
My lord, may I just indicate two
Yes.
things? My lord, the 3 kata lands where the club has constructed its own building. My lord, that is completely taken by the club. So that's why the park is just adjacent to the club. That's why we do it there.
And that is
May I,
Correct,
sir,
yes.
kindly allow me. Yes, my lord, that is police permission yet to be.
Oh, তাহলে যেখানে পারমিশন আছে সেটা পারমিশন স্টেটের
Yes,
as granted permission যেখানে বললাম না, police does not have any objection if the puja is held. ঠিক আছে? এবারে লিখুন, learned advocate for the petitioner submits that the park is just adjacent to the place which is recorded in the name of the petitioner club. Stop paragraph.
No, no.
The mm, um, as the petitioners are conducting the puja for quite some time past, accordingly, the court is of the opinion that the petitioners may be permitted to conduct the puja in the same place, in the manner as it was held earlier. Stop. The construction of the pandal or performing the puja is not going to create any right, title, or interest of the petitioner over the subject plot of land. Stop. The civil rights of the parties shall be adjudicated by the competent civil forum. Stop. This order is passed. Now, the order passed today is, however, subject to any order that may be passed by the Honorable Division Bench on 8th September 2025. The writ petition stands disposed of.
Two pujas, my lord. My lord, one thing, my lord, Durga Puja and Kali Puja, both we have sought permissions.
Acha, Durga Puja and Kali Puja.
They have asked for.
I'm so grateful. I'm extremely grateful.
For so much so that they will logically record the fact that they have sought permission for 400 cutters of
No, my lord. That is not a subject matter of the. That is not pleaded.
How much area will you require?
My lord, may I just say,
Yes,
400 square feet with regard to your lordship's order in 2023 was granted because they had excavated the.
Now, how much you will
We
require?
did the entire park. One side the puja pandal is there, and the other side for the mela and all. That is all, my lord. And my lord, everything is temporary. That is the permission granted. Even in 2023, 2024, the same permission was granted. My lord, I have annexed the orders.
Yes.
And these are
400 was 400 was.
these are society.
These are submissions from the bar, my lord.
Your lordship only says
Nothing on record.
The permission will be granted subject to the fees being paid. You can charge.
Permission has not been. Your lordship has taken use of utmost respect. Your lordship has not given the opportunity to the municipality after the filing of the writ petition as to take whether to give permission or not give permission. Since your lordship has taken the Kajal among your lordships to grant the permission, we have got no further thing to argue for your lordship.
All right, on the 8th, you please obtain an order. Yes, call the next matter. Yes.
I am for the petitioner, my lord.
Yes.
Yes, my
Lord,
lord.
I am appearing on behalf of respondent number 6, my lord, the answering respondent. My lord, perhaps, my lord, this writ is misconceived.
Malda Jilla Regulated Market Committee.
My lord, I'll just take 1 minute. Thereafter, my lord, if your lordship allows. My lord, the thing is, my lord, there was a direction, my lord, that the allotment would be done by way of lottery, wherein my
allotment of
lottery of
stalls.
stalls.
All right,
My
stall.
lord, wherein, my lord, it was by my lord Justice Moushumi Bhattacharya at that
Yes.
juncture, where the petitioners present had also represented. My lord, there it was found that the majority of the stall owners has been allotted stalls based on that lottery system. Now, my lord, today they have come up with a challenge.
Yes.
The challenge is a gross accusation of arbitrariness.
That is my
The
page
reason
24.
is, I'll take your lordship to that. The reason is that you cannot implement the new guideline. Now, my lord, what is the new guideline? These are banana stall owners. So initially,
When was the lottery held?
my lord, this was held long back, long back.
And the petitioner did not get a stall.
No, not that, my lord. They are association, trade union sort of.
All right.
Well, what has happened? I'll take just 1 more
No,
minute.
let him place. Let him place. No, please wait. Please wait. Page 24.
Madam, I am placing my can turn to page 24. Please.
Yes. Yes.
The allotment when my landed.
Distribution of stalls in auction platform 2022.
Yes, my lord. 2022, madam, that is my lord. From members, in reference to the above mentioned subject, this is to inform you that the marking numbering of stalls, which marking V1 to 88 has been completed. Now for distribution of marking stalls amongst your association members from numbers V49 to 87. That is my members. undersigned within 35 May 2022 positively. My lord, in the above you are requested kindly take necessary action at an early date from your end and completed the stated work within such and submit the distribution list along with 2 sets of non-judicial stamp paper worth rupees 200 each and 7 numbers of dummy papers in favor of the undersigned on 30 May 2022 positively. Thereafter, my lord, I have complied the same. That is my lord. Next annexure, that is P2. I have submitted with reference to the above. We are submitting 2 sets of non-judicial stamp paper with the rupees 208 numbers.
Now what has happened? This stall has not been allotted.
Now, my lord, they now taken new plea where they are not giving. Some of the members are giving 31 years lease. That is, my lord, kindly turn to page 39. 31 years of lease have been granted. Some of members.
And the others?
And others have not been given. That's why I have made a representation.
Lease has not been given.
No. That's why I have made a representation. DM is the chairman of this committee. But my lord, the representative, the regulator and committee secretary has stated that no, it will be given 1 year, 11 months, and on rental basis. I have challenged that.
Where is
when
that
they have
portion?
taken the money, 2000 in the year 2022, but they have silent in this matter and given some of them discrimination, some of them given my lord 2 or 3 members given my lord 31 years lease. That I have shown to your lordship. My lord, can turn to page 37, 31 years lease agreement. Now I am made several representations that amongst those remaining members.
Yes.
My lord, just to answer, the first letter which was shown to your lordship, my lord, that was the cause of action based on which the earlier writ application was filed. And my lord, this is the order which was passed. My lord, may I
Just tell me one thing.
Now, my lord, there your lordship's query is that why is it that some got 31 years and some did not?
Why discrimination?
My lord, subsequently, my lord, for the benefit and welfare of all these poor people, my lord, a guideline has come. The guideline is to the effect that those who have already taken a stall and had entered into an agreement by paying a ad hoc amount of around 4,50,000, that amount would be adjusted against 31 years monthly rental. Because that time it was non-refundable security deposit. Now what they have done is that for the new ones, it will be 2 months.
New ones means they also participated in the same lottery. They participated in the same lottery.
There are few again, my lord, where the stall stands vacated, my lord. These are the new ones where
those who have not participated in the lottery earlier, new steps, all right. But those who were there in the lottery, participated, stalls allotted, why will they be treated differently?
Those who had allotted stalls based on the non-refundable amount of 4,50,000, which is their line based on the agreement earlier. So now that was a refundable one, non-refundable. Now what it has happened, they said that there is no requirement for any non-refundable security deposit. If any stall is being allotted, at best 2 months of rent will be taken and that will be again adjusted. So that is what is the present scenario, and it will be every month the thing will be renewed. But those who had already paid 4,50,000, for them, my lord, every month from that amount of 4,50,000, the amount is being adjusted against the rents.
Very well. Now, if the petitioners are similarly situated with those people who paid 4 lakh of rupees and they want their...
If they are, then they will get the same benefit, but the petitioner is the association, my lord.
There may be members.
The
petitioner is represented by the secretary.
Secretary of the association.
Yes.
We have given it to the...
There should not be, the idea is there should not be any discrimination.
Absolutely.
For the new ones, you come up with your new guidelines and they can be guided by those guidelines. But those who are of the same...
Those who have not handed over that non-refundable amount of 4,50,000, for them it will be, my lord, that 1 year, because this amount has already been deposited, which will be adjusted for that, because the amount...
Where is the representation of the association challenging such action?
My lord, that is the P1, but that challenging
the action of
I made a representation, that is my lord. before the
Chairman.
district magistrate collector, who is the chairman.
When?
That is, my lord, page
42.
42, yes, my lord. 42 and another reminder also 44. 44 reminder also given. We are ready, and it is newly they have introduced.
Please come.
24.
The association is the writ petitioner in the instant writ petition comprising of members who participated in a lottery for allotment of stalls conducted by the Malda Jela Regulated Market Committee in the year 2022. Stop. In furtherance to the lottery, stalls were allotted to the selected members. Stop. In respect of a few of the members.
My lord, just amount, my lord, as per the order, it was out of 39 banana traders, 34 was allotted who had
Very well.
participated.
अच्छा কি বললাম
Well, may I hand over?
No, my lord.
Few of the members না sentence টা selected members if deed was executed, lease deed was executed, but the deed has not been executed in favor of all the selected allottees.
My lord, only one thing, my lord. My lord, the
Stop.
agreement was executed against some, but allotment has been done to everyone. That is the thing.
And the same stalls.
But the deed has not been executed in favor of the selected allottees.
In respect of all the selected allottees. Stop. The Malda Jela Regulated Market Committee presently intends to vary and modify the terms and conditions of the lease. Stop. The association and its members are aggrieved by the same. Stop. An objection by the association is pending consideration before the district magistrate, being the chairman of the market committee. Stop. The petitioners submits that there ought not to be any discrimination in between the members who were allotted the stalls. Paragraph, learned advocate representing the market committee submits upon instruction that the members in whose favor the deed was executed had deposited a lump sum amount on account of security, which is currently being adjusted by way of monthly rent. Stop. The members who have not yet deposited the security will not be required to deposit the same, but would be liable to pay rental on monthly basis. Stop paragraph. Upon hearing the submission made on behalf of both the parties and on perusal of the documents placed before this court, it appears that the market committee conducted a lottery in the year 2022 and allottees were selected in the said lottery. Stop. The allottees are liable to be treated equally. Stop. The committee ought not to discriminate between the allottees who were selected for allotment of stalls in the subject lottery. Stop paragraph. An objection from the association is already pending disposal before the chairman of the market committee. Stop. The district magistrate and chairman of the committee is directed to consider and dispose of the same. Dispose of the objection. Hmm? Dated 26th May 2025. Strictly in accordance with the
And my lord, till date, my lord, that is issued, that is 4th August 1825. Prayer 1, prayer A, my lord. That should be, my lord, state, my lord.
My lord, may I just add a word, my lord, to this? My lord, instead of writing, my lord, that executed agreement, my lord, kindly mentions to whom it was allotted. My lord, this is the division bench order, my lord. In the second page, my lord, kindly sees out of the total 34 who were qualified, my lord, 30 were already, my lord, handed over and they had signed the draft agreement. My lord, for few, my lord, the execution of the deed is still pending, but the amount has been transferred. So what we are doing, my lord, for everyone who has paid upon presentation of the receipt, my lord, everyone will be given the exemption of not to pay for 31 years. Those who have not paid, my lord, they will be getting into the fresh term and who were not a part in that lottery.
See, those who are not a part in the lottery, you take steps.
My lord, your lordship has already clarified that. Only
But
thing,
then
my lord,
those
your
who
lordship
have been
is deed executed. Kindly, instead of that, my lord, kindly mentions the allotment. Those who have been allotted the stocks. Only this much.
see, in whose favor you have executed, it is all over.
My lord,
Nothing to do for them.
my lord, and kindly then adds those who were, because there were others who had signed the draft agreement.
Yes.
They also paid, but did not execute till now. Man, for them
No,
also
if
the amount is with
those people who have signed the draft but not the deed is yet to be executed formally, will they fall within the same lottery or they are subsequent?
No, my lord, same. Because they had participated, then paid also. For all those who have paid 4,50,000.
Yes, they will be covered by the
But my
same.
lord, since your lordship specified the word, they have
Executed.
executed the lease,
Huh?
that will create an impact.
What is the problem that you are
My lord,
apprehending?
there are those who had actually signed the draft of the lease agreement, but not formally executed. So that is still pending. For those, but since this was already paid, we do want to give relaxation to all. We don't want to be partial. So whoever.
All
has
right,
paid.
I'll check it up. কি বললো? Accordance with the prevailing rules at the earliest, but positively within a period of 6 weeks from the date of communication of this order.
We went there and submission there for execution of the deed.
A reasoned order shall be passed and made known to the association. Stop. And the reasonable opportunity of hearing to the other one. I'll see what is here and
Yes, ma'am.
check up.
My lord, I have handed both the orders, the division bench as well as the single.
And a report may be handed over to me, my lord. And
Where is the report?
Memo,
There is no report.
my lord. That is input memo dated 1st August 2025 should be, my lord. That is prayer E, my lord.
My lord, that
Not to
that will affect everyone. My lord, kindly sees the content of that. That's page 45. Kindly
Yes,
sees,
page
we say that
45,
we are
yes.
going to give the benefit. If this is state, we will not be able to give the benefit.
Page 45.
But this will be possibly prospective. It cannot go back to 2022. I have not read it.
Whoever has got into that paid 4,50,000, they will get the benefit of 31 years. The rest, my lord, will also get the benefit of non-refundable.
I am not looking into it. I have mentioned that there should be no discrimination.
My lord, much obliged. Much obliged.
I beg to appear for the respondent bank, my lord.
I beg to appear on behalf of the petitioner, my lord. But the case is that, my lord, the petitioner is neither the borrower, but he was suddenly ousted from his home along with his 70 years aged parent and two daughters whose examination
For
is
the bank, you say?
and,
For the
and
bank, my lord.
another
Which bank?
Punjab National Bank, my lord.
There is Bank
There
of
are
Baroda
Bank of
also?
Baroda has no
I am
role to
sub.
play. Oh, yes.
Yes.
There are private respondents also.
Yes, so many
Now, the
private.
point to be decided before your lordship, my lord. Point to be decided before your lordship, my lord. They are challenging the validity of a mortgage, my lord. dispute is that, my lord, their property has been mortgaged to the Punjab National Bank in the year of 2012. Same has been mortgaged to the Bank of Baroda in 2018. Now, this is the main issue.
You are
Yeah,
for
bol-
the Bank of Baroda? All right.
Madam, kindly take table to look at page 1131 once, madam.
Yes.
Kindly see that the represented by Pintu Pakhira and Debobroto Sarkar sold to Aradhana Sarkar in 2012 March, my lord. That is at page 110. Well, the same property was sold, page 57, kindly see, my lord.
That's another
Another case, my lord,
Yes,
Lordship has interfered on this ground. There is a discrepancy regarding a flat, a description of the property number.
Yes.
On that day, we have take possession of this property. Now this person's approach. Now, my lord, now, my lord, in disguise of this writ petition, my lord, they are challenging the validity of a mortgage.
All right, let me see.
Yes.
Well, kindly take a look at page 57 once, my lord.
Page
57.
57. Yes.
Kindly see date 27 November 2012. Earlier source, my lord, March 2012. The next page is the same Debobroto Sarkar Pintu Pakhira. Sold to Moha Chatterjee. Now, my lord, kindly see the below, my lord, there was a stamp of Bank of Baroda over this deed.
Page?
Page 57.
Bank of Baroda.
Baroda. Now, my lord, will kindly, I purchased the property from Moha, that is at page 22.
Yes.
Now, my lord, kindly see the Bank of Baroda issued loan in favor of me, that is at page 84. Same property sold in the March, same property was sold in the November. And kindly see the loan was sanctioned by the Bank of Baroda.
Yes.
That from bottom, my lord, second portion, upfront charges, 8,000.
850.
This is for the searching and all those things. After all those things, Bank of Baroda issued me the loan. Now, my lord, will kindly take table to look at. I have paying the entire EMI. My lord, your lordship will find from the page 88. I've never made any default. Now, my lord, no notice, nothing. Nothing was issued me. Now, kindly see, my lord, page 102. 100, my lord. This is my
No. Now what has happened? The bank has taken possession.
bank on 20th August suddenly came. No notice was served upon us. Disposes my 70 years old mother along with my daughter, whose examination scheduled to be held on 5th. Now, my lord, your lordship knows because earlier matter your lordship heard. There are two flats. One notice was issued. They challenged before your lordship, but the main proceedings was filed by the borrower before the DRT in respect of that flat as well as this flat. Proceeding is pending there, but I don't have any knowledge, my lord. No notice was ever served to me.
Now you got the knowledge?
My lord,
Now you go over
They
there.
have just handed over the order of the DRT.
Let me see.
Yes, they can added themselves a party, my lord. They can raise
for that.
I am not.
For my
I have
personal
made
defense, my lord, I am just handing over the
have
order.
copy.
Yes,
All right.
very well.
My lord, I will add, certainly add, my lord. I will not say it, my lord, but kindly give some protection. I am now under, my lord. My lord, kindly see, my lord, I have no Bank of Baroda issued the loan in favor of me, my lord. Kindly give certain. So
There is no dispute between you and your the Bank of Baroda who has granted you loan. That is not the issue.
Yes.
After searching all those things, I am a, my lord, innocent person.
Innocent person, go over there. What can be
Kindly
done?
give some protection, my lord. Because
No protection can be given.
Well,
There
kindly-
this is public money
Yes.
and loan has not been repaid.
Well,
The court
I
cannot
am not.
help.
I am neither the borrower. Kindly see, well,
Somebody else is at fault.
nobody has no notice. Nothing was given to me. I am
The
with my
petitioner
now under my
claims
clear
to be-
case, my lord.
In their
Well,
pleading,
kindly
they
consider,
said
my
that
lord.
they have not.
I am giving a full
Petitioner-
protection, my lord.
Petitioner claims to be purchaser of certain property which has been taken possession of by the Punjab National Bank under the provisions of the SARFAESI Act. Stop. Learned advocate for the petitioner submits that the petitioner is neither the borrower nor the guarantor Stop. The petitioner did not obtain any loan from the Punjab National Bank. Stop. Without serving any notice upon the petitioner, comma, the Punjab National Bank has taken possession of the property by dispossessing the petitioner and his aged and ailing mother and minor daughter.
Examination scheduled to be on 5th, my lord. And books are all in
Stop.
flat, my lord.
It has been submitted that the examination of the minor daughter is due to be held from 5th September 2025 and all her books and belongings are lying inside the subject flat. Stop. Prayer has been made to direct the bank to hand over possession to the petitioner, as the petitioner is not at default. Stop. Next, learned advocate representing the Punjab National Bank submits that the borrower has already filed an application, securitization application, before the Debts Recovery Tribunal, which is pending. Tribunal being case number SA 205/2022.
2022.
Aradhana Sarkar and another versus PNB. And the same is pending consideration. Stop. It has been submitted that there is huge sum of money that is due and payable by the borrower. Stop. Paragraph. Upon hearing the parties and on perusal of the materials on record, it appears that the petitioner purchased the property which was mortgaged to the Punjab National Bank
In 2012.
in 2012. Stop. Due to non-payment of the loan amount, comma, the bank took steps under the SARFAESI Act and obtained possession thereof. Stop. The petitioner in the meantime purchased the property from the borrower. Stop. The petitioner has also obtained
I have not
loan.
purchased from the borrower, my lord.
You are
I have
from
the purchase from the subsequent purchaser of the borrower. Previous. I am
So
no
it has got so many, it has changed
My lord,
hands.
one thing, my lord, kindly
Imagine.
give me 1 minute, my lord, I will show, my lord.
No, 1 minute. Ki bollam? The petitioner is the subsequent purchaser. Is a subsequent purchaser of the mortgaged property. Stop. As the bank has taken steps as per the provisions of the SARFAESI Act, comma, the court is not inclined to exercise jurisdiction in the matter. Stop. However, since it has been submitted that the books and belongings of the minor daughter of the petitioner is inside the flat, possession of which has been taken by the bank. Accordingly, the court directs the bank to permit the petitioner to take back his belongings. Stop. How soon can you take back all your things?
Whenever your lordship directed, I will. Tomorrow,
Within 48 hours. Within 48 hours. Stop.
Friday is a holiday, my lord. Give us, my lord, to us.
Tomorrow, let him take it. By tomorrow.
The tomorrow exam, why don't you approach the court before? Possession was taken on 4th August.
By
20th August, I was disposed.
by 48 hours আপনি লিখুন, কারণ অর্ডার হবে, আপলোড হবে, it will take time. 48 hours, ঠিক আছে? The articles shall be removed in the presence of the representative of the bank by preparing a proper inventory list. The process of removal of the Articles shall be videographed by the parties and be preserved for future reference.
Lordship, kindly direct the concerned police station to give us assistance. Otherwise, there may be some problem occurs.
Without police help.
Which, yes, exactly, disposes without
police
police
help.
Yes.
and now you apprehend that the
Kindly
police.
Police is there,
Malad,
the section 14 order has to be executed by a
2018. Malad, I purchased 2019 loan was sanctioned by the PNB. 18 purchase and Malad, Bank of Baroda, Malad, page number 105. Kindly see one.
It will be open for the bank, Punjab National Bank,
yes,
to take the assistance of the local police station at the time of removal of the articles by the petitioner.
we cannot execute a section 14 order without the police help.
It will be open for the petitioner to approach the debts recovery tribunal for relief in accordance with law, if so advised.
Malad, if it is approach, Malad, it should be decided expeditiously.
Next.
Wait to do it.
Hey, please, Your Lordship. This is my writ petition challenging a request for proposal which has been floated by DVC, my lord, which is a limited tender where they have already mentioned 3 bidders who will be only participating. Despite the petitioner before Your Lordship is there in a subsisting contract, despite the petitioners, my lord, fulfilling, my lord, I can't say what is the eligibility criteria. There is no eligibility criteria given in the tender. Kindly sees the terms. Kindly takes a look at page 248. Now, the tender was, this is the bid summary, my lord. Page 248 of the second volume, my lord.
Yes.
My lord, bid summary, my lord, why I mentioned for the urgency. My lord, the tender was floated on the 22nd of August. Kindly sees the bid last date is 8 September, bid opening date is 9 September.
The tender
towards the
was
middle of
the tender was floated in the GEM portal. Where was it floated?
Yes,
Where
GEM
from? GEM.
GEM portal.
Right. Organization is DVC. Date. Where is the date?
My lord, there is a third, there's a fourth column, my lord, fourth row, critical dates, if your lordship kindly sees. Fourth
row.
Towards the end of the, towards the
Critical dates.
critical
Yes.
dates. Kindly sees the published date is, my lord, 22nd August.
22nd August.
My lord, kindly sees the bid opening date is 9 September and my lord, the end date, bid download date is, my lord, 8 September. So, and bid submission date is also 8 September.
So 22nd August it was published and the submission end date was 8
September.
So you had time.
No, I cannot participate.
That is different, but
Yes.
time was there. Next.
Yes. Now, my lord, your lordship would kindly have a look at the next page. This is 249.
Yes.
The material is procurement of high chrome grinding media ball. This is required, my lord, for crushing coal. And my lord, the crushed coal would be
whatever. Yes, then.
Yes. Kindly sees the next line, limited tender inquiry.
With
Now, my lord, will
e-reverse auction. Yes.
We'll kindly have a look at page 276.
Yes.
So there is a table there.
Right.
Just below the table. This tender is being processed on limited tender inquiry basis with approval of competent authority. Offer of the following bidders will be only accepted. Any bid not meeting this criteria will be outrightly rejected during bid opening. And the 3 names your lordship would find, one entity from Ahmedabad, one entity from Jamshedpur, one entity from Jaipur. Now,
but then the tender document that you showed, it's an open bidding process.
No.
Anybody could have bid it.
Nobody could have bid it.
Why?
Nobody could bid. It's only, kindly sees that is the language. Offer of the following bidders only will be accepted.
This must be the next stage.
But that is not evident from the tender terms. If they tell that, but even if that is the next stage, then I would be bidding for nothing. So if they have made this clause that only the bids of one out of these 3 would be accepted, then I participating in the tender is not futile. So this tender is just a facade to show a compliance with of Article 14.
All right.
Otherwise, my lord, because we do not find any term from this tender which would, my lord, permit us to bid because of that clause.
All right.
3 named bidders.
I get it.
Now, my lord, your lordship would kindly have a look at page 309. My lord, when we see this RFQ, kindly permits me to use the acronym RFQ. My lord, we issue a letter of 22nd of August to, my lord, the respondent. 26th of August. I'm
Yes.
sorry, 26th of August.
Right.
Indicating, my lord, because we were informed, my lord, and this is all oral, we have been informed that NTPC's criteria would be imported for DVC.
All right.
Nothing is evident from the tender term, subject to correction by my learned senior friend. The tender does not say any qualifying criteria, A. B, it does not say that what criteria has to be imported. From where? It is silent on that. When the petitioner number 2 visits their office, they have been informed orally that NTPC's criteria is what is applicable. To that, my lord, we have by this letter indicated that, see, we also fulfill NTPC's whatever is requirement, because we are doing work of 25 crores odd with NTPC.
Very well, I have followed. Let me hear then.
And, my lord, the next clause is, my lord, the other thing, my lord, only one other document. My lord, they kindly sees the next page, 315. This is my other letter. Pursuant to a meeting which was given to me. That is the first sentence, my lord. At page 315.
Yes.
My lord, we have been told, and kindly sees the second paragraph. This is where I have pleaded it specifically in this letter. That while the requirement PR for the above subject is being processed internally, as per COS under ED operations has informed us that they have referred to NTPC vendor portal and accordingly suggested CNM for 3 vendors who are eligible or capable for this requirement, which mentions clearly that the vendors in the tender documents. Further, COS has also informed us that our credentials are not considered and referred to CNM due to being shortlisted by NTPC vendor portal due to difference in estimated value and our execution capability value as per NTPC vendor portal. Precisely, the current NIT estimated value is 17 crore and our execution capability as per NTPC portal is 13.85 crore. This is what they have said, but this is also not correct. Kindly seize my pleading. I have the capability of 200 crores. I have pleaded that. Kindly
is anybody's financial criteria?
It's not evident from the tender.
Right.
No criteria is mentioned. That why I am excluded, why 3 are selected, in my humble understanding, subject to being corrected by my learned senior friend, my lord, I do not find any clause in the tender that why these 3 are the chosen few.
Tell me one thing.
Yes, my
page 248, tender type.
Yes, my lord.
The 4th row from top, basic details.
Yes, my lord.
Tender type. It is limited. What does it mean?
That only the persons to whom it is limited, they can participate. It is not an open tender.
It's not an open tender.
Now, kindly, my lord, permits me to place only one judgment on this.
Right.
That, my lord, where these kind of tenders are floated, my lord, this is ex facie, my lord, in violation of, my lord, Article 14. 2023-19. But I shall trouble your lordship with only one judgment. And it will kindly have a look at, this is 2023-19 Supreme Court cases 755. Your lordship would kindly have a look at page 11 of this, my lord. The page number is at top left, my lord.
Yes.
Kindly see paragraph 2. 6 paragraphs I shall place, my lord. Paragraph 2, the first respondent Kerala Ayurvedic such and such, the Constitution of India, by a judgment in such and such, division bench of the High Court allowed the petition and directed that the state Uttar Pradesh must purchase Ayurvedic medicines by adopting a transparent process after inviting tenders. The state of Uttar Pradesh and IMCPL instituted proceedings under Article 136 against the judgment of the High Court. Then 3, the principal issue is whether, in view of para such and such of the operating guidelines of the National Ayush Mission, the applicant could have procured Ayurvedic drugs solely from IMCPL without inviting tenders. Now, kindly terms, kindly takes a look at paragraph 14 onwards. This was a case of solely, and ours is
Limited.
Is 3, just to show Malad.
Limited.
Yes.
Yes.
Kindly takes paragraph 13 Malad
Hmm.
at page 17.
Yes.
State largest conflation and power and duty. The welfare state plays a crucial role in aiding the realization of the socio-economic rights. My lord, this concerns with the state largest, and my lord, how a state largest is to be given. Then, my lord, we'll kindly have a look at my lord, paragraph 16. But paragraph 14 deals with that the discretion by nomination is not available. May I place it? Paragraph such and such prescribes entities from which Ayurvedic medicines may be procured. The paragraph does not prescribe the method through which they may be procured. The appellant contend that since the method of procurement is not prescribed, it has the discretion to purchase drugs through nomination. On the other hand, the respondent contends that merely because the operational guidelines do not prescribe the method of procurement, unbridled discretion cannot be given to executive to procure drugs through nomination. This is also a nomination of 3. Out of that 3, I will select 1. Now kindly turns to the next page. In fact, paragraph 15, Malad. In the early 1950s, judicial review of the process of concluding contracts by the government was limited. The court salad, Malad, I really need not trouble your lordship with that. Kindly seize paragraph 16. Over the years, this court has applied the non-arbitrariness standard under Article 14 to test the validity of government action. In Ramana Dayaram Shetty versus Airports Authority of India, a 3-judges bench of this court observed that the government does not have unlimited discretion in granting state largesse and it must act in fairness. In New Horizons Limited Union of India, the Department of Telecommunications invited sealed tenders for printing, binding and supply of telephonic directories. While determining the validity of the eligibility criteria prescribed for tenderers, the court observed that the state, while entering into a contract, does not stand on the same footing as a private person. The court held that the government cannot act arbitrarily while dealing with the public, whether it is for giving jobs or entering into contracts. The relevant observations are extracted below. New Horizons, Malad. This is, Malad, a 5-judges bench. At the outset, we may indicate that in the matter of entering into a contract, the state does not stand in the same footing. What is been paraphrased here, but it's given. Then Malad will kindly have a look at paragraph 21. In such and such, the respondent has granted a license for a year to run a slaughterhouse owned by the appellant corporation. On the completion of the terms of the license, the appellant issued an advertisement inviting applications for granting a fresh contract. The respondent challenged the advertisement. The court observed that it is the requirement of the principle of non-arbitrariness postulated in Article 14 that contracts by the state, its corporations, instrumentalities and agencies should, as a general rule, be granted through public tender. Noting that it is necessary to maintain transparency in the grant of public contracts, the court ruled that the state must give contracts only by tender and not through private negotiations. This court held that a contract can be granted by private negotiation only in exceptional circumstances, having regard to the nature of trade or largesse, or for some other good reason. Some of the exceptional circumstances that were listed are, but this is in case of natural calamity or emergencies. Then, my lord, situations where the supplier has exclusive rights over the goods and no reasonable alternative. Then C, there are no bidders where the bid offer is too low. The court was upheld that the award of contracts without holding a public auction in situations where conducting a public auction is impossible given the surrounding circumstances. So, my lord, my submission is that the tender terms also does not show what is an emergency situation which has compelled them to, my lord, follow this route. Now, 3 paragraphs of the petition to show I am qualified, and I shall conclude, my lord. Kindly takes a look at, my lord, paragraph 18 first, my lord. No, in fact, 18 was what was said to me. Paragraph 20. Moreover, the petitioners have not been provided with any level playing field as stated earlier. The petitioners have a manufacturing capacity of 25,000 metric ton per year, which translates to approximately 200 crores. Thus, the petitioners could not have been said to be lacking in any eligibility criteria.
Have
Their
you
20 marks-
performed any such work?
Yes. Kindly sees the next paragraph. The respondents have made an attempt to create a class without there existing any. This would be evident from the fact that the petitioners have themselves successfully executed a single contract value of more than 22 crores at DVC. The respondent number 1, that is down the, this would be evident from documents I have annexed, that is P10. Thus, then, my lord, the next paragraph, even with NTPC, my next paragraph where I have said that, my lord, even for NTPC, my lord, I am doing contract, that is at paragraph 25, I have given the value more than 25 crores with NTPC also. Paragraph 25 at page 11, my lord.
All right.
So, my lord, in no way I can be said to be an entity incapable of participating in it. I have the capabilities to participate, and the tender is silent on any qualifying criteria.
All right.
Those are my submissions.
Yes, please. What does this word limited mean? And how are you limiting it to only 3?
There are two parts to the submission which has been made by my learned friend. First question, my lord, is whether a limited tender is permissible in law. Second is, if the answer to the first question is in the affirmative, whether there is any infraction considering it is a limited tender. Because, my lord, if I am able to show to your lordship that the first is it is permissible in law, once my lord holds that limited tender is permissible in law, I can limit it to, if it is, because, my lord, it's a open secret that usually we have the open tenders, but limited tender is you identify this. Now, why this concept of limited tender and whether it is a new concept or not? Limited tender has been existing, my lord, for the last 50 years. Lord, what is a limited tender? I'll tell your lordship. Lord, in some projects which requires, my lord, for instance, high security, or, my lord, public purpose is involved where high specialization is required, my lord, various public sector undertakings, instead of, my lord, wasting money and time on open tenders, my lord, where anybody and everybody can come in and facing writ petitions all over the country challenging the tender, they limit their vendor list to a common vendor list of anybody. Here, my lord, what has happened, and I'll show your lordship, my lord. My lord, we entered into an agreement with NTPC. My lord, NTPC is one of the leading power generators in India. So, my lord, and with NTPC, there are other state power bodies also who have entered into a similar agreement. What is this? That this is sharing of vendors list and expertise. Because, my lord, NTPC contracts are the largest, my lord, in the country. So, my lord, we entered into an agreement that for certain equipments, my lord, in this case, we are talking of ball crushers. My lord, a ball crusher is used, my lord, in the equipment which crushes the coal. Because, my lord, if that is not of the requisite strength, my lord, the coal will not be crushed in a proper manner, and that will have in turn, my lord, an effect on the coal supply, which is, my lord, a prime raw material of the power generating company, DVC. So we are talking of ball crushers. In this, my lord, from January 2025, because of, and this is a policy decision, I have that with me, I'll show to your lordship. My lord, because of the policy decision, NTPC vendor list will be, my lord, the approved list for these limited tenders, that whoever are vendors for NTPC, they will be eligible. We do not go for an open tender in this sense that, my lord, it's not open to all and sundry. So first is you have to qualify for NTPC vendor list. And, my lord, the petitioner already showed to your lordship, they are doing projects for NTPC. Now, my lord, how do we select that? We are not the persons who select it. It's a system in the NTPC system itself, that moment we give the value of our work, my lord, they have the vendor list. We have an initial vendor list of 6. From that, we shortlisted 3 because, my lord, roughly our project, this tender value was around 17 crores. And in the NTPC side, my lord, their valuation in the NTPC, not what they have done with us or anybody, it was 13.5 crores. And, my lord, this is to their knowledge because they showed to your lordship that. So that is why these figures are coming. So, my lord, once we say, my lord, and this is, my lord, an automated system. In the NTPC, we say that, well, we are purchasing ball crushers, the vendor list will come. We have the printout of that. My lord, originally 6 lists comes. My lord, this is the list. This is the original first list.
My lord, kindly do not permit, because this is not part of the tender terms. It is not available
I will,
anywhere.
I will
Yes,
put it in affidavit.
It's not available anywhere.
wait.
So your
And
lordship
if there is
kindly,
stage,
your lordship would kindly treat this ARFQ on the anvil of whatever is available.
Yes.
Milord, I don't think I have to put it on tender terms. I'll come to that. If my learned friend doesn't want to take it, he is free to. I won't. So, my lord, this is what is coming in, my lord. So far as this is concerned, vendor list as per the NTPC side, these 6 will come. And moment, my lord, the valuation is given, my lord, this will come in. And my lord, if my learned friend wants, they can verify it from
Three
NTPC.
goes out
3 goes out and 3
because
comes
of
in.
the
My lord, and I'll say why this is done. My lord, today,
figure.
yes, today, if I want to, my lord, let us say, rebuild a portion of this high court, my lord, your decision is taken, I'll only have the 3 best available. My lord, I may call Larsen and Toubro, I may call Tata Construction, I may call that. And my lord, I may only restrict the tender to a, what is known as a limited tender. My lord, in law, limited tender is permissible. I'll right now show a judgment. Second, my lord, once I do this, and I agree with my learned friend, the test is of rationality and fairness. The judgment of Justice Chandrachud, my lord, the bench headed 2023, lordship will find the tender contained limited tender only for one person, IMCL. And it is in that context that observation was made. Why hold the facade of a tender if it is for one person? You don't require a tender. On one hand, you are showing, but this is, my lord, the top 3 as per the NTPC list has been done. Now, my lord, the policy, I have also, my lord, got hold of the policy. This is the policy of DVC from January 2025. Yes, I'll put it on affidavit, my lord. I am only, my lord, showing it because of the, my lord, lordship will kindly take, my lord, the second page. I'll just read the second paragraph. DVC has not yet finalized the vendor enlistment process, which is critical for ensuring the procurement of quality spares and consumables. This delay has become increasingly concerning as it has been observed materials supplied by certain non-reputed vendors are failing frequently, often just after the warranty period. These failures have resulted in unexpected breakdowns of equipment, which in turn are causing potential power generation losses. The lack of reliable suppliers is directly impacting the operational efficiency and reliability of our systems. NTPC, being one of the leading and reputed entities in power generation, procures material only from enlisted vendors. They follow a thorough and established vendor enlistment process and ensuring the procurement of high quality material. Considering this, we propose to seek consultancy services from NTPC so that we can benefit from their vendor enlistment list, which is prepared prior to floating tenders. And then, my lord, the details have been given how the entire exercise. My lord, it's a longish document. I am only trying to show that it is part of a comprehensive policy. Now, my lord, the question of law, whether limited tenders are permissible and whether, my lord, I can choose. My lord, once I say I want the top 3, or, my lord, it satisfies a rational, my lord, criteria. My lord, kindly look, my lord, this is as old or as early as 1982, AIR 83, Gujarat 86. ওদের একটা কপি দাও গুজরাটে। This was a judgment of Justice Ahmedi, my lord, before when he was a judge of the Gujarat High Court. Lord, I just show your lordship 3 paragraphs, portion of 3 paragraphs. My lord, firstly, kindly come to, my lord, paragraph 6. Paragraph 6, lordship will find the heading HAPA transshipment point. Then, my lord, I just skip first 4 lines and I read from the 5th line. The HAPA transshipment point came into existence in June 80 when the broad gauge lines were extended up to HAPA under the Viramgam Okha Porbandar project. The transshipment point therefore temporarily shifted to HAPA pending completion of the project. The petitioner contended that railway administration, by resorting to the limited tender system, awarded a contract of 1 year from 15 June to 80 to 15 June 81 to Messrs. Lotus Handling Company. Under the limited tender system, only a few experienced contractors are invited to submit their quotations. According to the petitioners, only those contractors who were their favorites were invited to submit quotations, and ultimately the contract was given to the aforesaid firm, which is the sister concern of Messrs. Chotalal, Jarmaksdas and Company, a monopolist in this line. Since the contract period was to expire on 15 June 81 and no fresh tenders were invited, the petitioners apprehended that the contract may be renewed without calling for fresh tenders, and hence they filed the present proceeding with a view to compelling the railway administration to resort to normal open tender system before granting or renewing so and so. So, my lord, the allegations were similar. I can't say it's exact. Now, my lord, kindly see paragraph 13. The Western Railway Finance Manual. Well, this is this tender was as per the policy decision. The Western Railway Finance Manual 1958 lays down work of handling and transshipment through any of the following agencies. And then, my lord, next page, where it is undertaken departmentally, class 4 staff has to be engaged at a few stations for doing the handling work. And then, my lord, kindly, my lord, come straight to the middle. Lordship will find just where, my lord, there are three sub clauses 1, 2, and 3. The line just before that in the middle. It then sets out different methods of inviting tenders as under by invitation to one firm only. So, my lord, single tender is also permissible as per the manual if it is a policy decision. Second, by direct invitation to a limited number of firms, limited tender, and by advertisement, open tender. Then, my lord, the code, the other features of the code was discussed. Kindly now come to paragraph 22. Paragraph 22, Lordship will find, my lord, at internal page 27 of the printout. Paragraph 22. That takes me to the challenge concerning the Hapa transshipment point contract contained in special civil so-and-so. The Viramgam transshipment point was the second biggest transshipment point on Western Railway next to Sabarmati transshipment, with the extension of broad gauge line up to Hapa on the Viramgam-Okha Porbandar project. The transshipment point shifted from Viramgam to Hapa sometime in June 80. This brought a material change in pattern of traffic as pointed out earlier while dealing with the contract regarding the Sabarmati transshipment point. The Viramgam-Okha Porbandar project was initially expected to be complete within a year, but unfortunately time schedule could not be adhered to. The question of awarding the contract regarding handling work to be carried out at Hapa transshipment point was therefore considered by a committee of senior officers belonging to different department of railway. The said committee decided to resort to limited tender method, which is one of the recognized methods for awarding contracts. As the railway administration was at a transition point so far as Viramgam-Okha Porbandar project is concerned, and as it was difficult to predict the pattern of traffic at Hapa, the committee felt that the contract could be given only to an experienced contractors who had a record of satisfactory execution of such contracts. They therefore invited 7 leading and well-known handling contractors to give their quotations. The petitioners were not amongst the 7 contractors. On the basis of quotations received under this limited tender system, the contract in question was given to Messrs. Lotus Handling Company for 1 year only, as it was expected within that time the Viramgam-Okha project would be completed and Hapa would cease to be a transshipment point. The contract itself contained a stipulation for its renewal on the same terms and conditions, as the railway administration was careful enough to visualize the possibility of delay in completion of the Viramgam-Okha Porbandar project. When the project was not completed...
Please don't read the whole thing. Only the important line that you would like to show.
Well,
that means it was accepted.
Yes,
the
it was
limited
accepted.
tender method was
Yes, it is
accepted.
accepted.
This is what is the main thing.
Yes. So, my lord, my respectful submission is, if Lordship, my lord, kindly comes to the last 4 sentences of paragraph 22, just before para 23.
To my mind.
To my mind, it is not necessary to refer to those detailed developments which are found in the affidavit in reply. What is necessary to judge is whether the railway administration has satisfied the twin test for upholding its action. I am therefore of the opinion that the challenge insofar as this contract is concerned is also without substance. My lord, twin test is, my lord, fairness and necessity. Whether it was necessary and fairness. My lord,
Yes.
here I have prima facie shown, and I can put it on affidavit, that it was a policy decision that we were facing failures of equipment because of, my lord, substandard material. So we decided we will go for limited tender. We entered into a consultancy agreement with NTPC, and, my lord, as per the NTPC list and, my lord, my financial value, whoever qualifies in the NTPC tender, my lord, is also, my lord, I take that limited. And, my lord, here there are the top three in the NTPC list in terms of, we have taken that. They are the top three out of the 6. Lordship will find they have the valuations also recorded. My lord, top 3, and, my lord, we have called for that.
And where did you get these valuations? You get it from NTPC.
NTPC portal, my lord. It's
open
a
portal.
It's a systematic system, my lord, in which, my lord, once we enter into that, my lord, this is the consultancy service which
That is
NTPC
coming.
is given, and I will put it on affidavit, my lord.
Sir, a quick reply, my lord, if your lordship
Yes, please.
permits. First, my lord, whether, my lord, first, my lord, whether NTPC can be relied upon for the purpose of DVC contracts. Please, my lord, take the document which has been handed up. Kindly come to page 15.
Which document?
My lord, this document which my
Alright.
friend has handed up. So, my lord, page 15.
Yes.
Consultancy services for DVC usage of NTPC vendor enlistment. Now, please come to the next page. Scope of services. NTPC USSC is doing enlistment of vendors in 2 categories. This is fine. But I must, everyone, not me, not me alone, we must get a chance of enlistment with NTPC or with DVC. NTPC uses their own enlisted sellers, vendors. So, my lord.
You are also there.
No, my
Yes.
lord, I am for DVC. I am also giving.
No, you are there for NTPC
Not-
also.
We have 1 or 2 contracts with NTPC. I have
Yes.
given particulars.
Right.
Now, I have to be given a chance to apply for enlistment if for this sort of a contract also, if he is going to
Thing is,
use.
the submission according to the corporation is that NTPC has a list where your financial criteria is uploaded and recorded.
Yes.
The figure that is mentioned falls below the
My lord,
contract value.
My lord, may I ask myself a question? Is it a part of the tender document? No. What is the criteria? Is it mentioned? No. Please see the tender document.
I have seen it. It has been shown to me.
Doesn't show. Doesn't show.
Yes.
My lord, kindly see 2 clauses.
Yes, yes. It has been shown.
23 and clause 25 at page 281.
Yes.
Basis 281, my lord. Basis of evaluation, clause 23.
Yes.
And 25, eligibility. Nothing is given. Next, my learned friend relies on a 1981 judgment of the Gujarat High Court, which is, my lord, contrary to full bench judgment of Supreme Court in the 1990s. My lord, one, my lord, judgment 2023-19 SCC 755. Your lordship has seen that?
Yes.
Just, my lord, see paragraph 21.
Yes, yes.
So, my lord, the law, my lord, is set, my lord, by the Supreme Court is not that you can never do limited, my lord, tender processes. But the law is that A, it should not be done unless there is natural calamity or emergency. B, where the supplier has exclusive rights. And C, where where there are no bidders or the bid offered is too low. And your lordship will.
The petitioners.
This was paragraph 21 of the Supreme Court judgment
Yes.
I was reading.
Right. The petitioners intends to participate in the tender process floated by Damodar Valley Corporation in the GEM portal. Stop. The tender details was published on 26th August 2020. Now published on 22nd August 2025. Stop. The bid opening date. The bid submission end date is 8th September 2025 and the bid opening date is 9th September 2025. Stop. The tender type is within single quotes limited. Stop. The request for quotation published by the Damodar Valley Corporation within bracket opore DVC likhe deben for short. Was for procurement 249. এটাকে কপি করবেন. Procurement of high chrome grinding media দেখুন. Page 249. ঠিক আছে. The limited tender inquiry with the e-reverse auction. ঠিক আছে. The tender process was restricted. No, the bid was only restricted to 3 entities. Stop. The RFQ clearly mentioned that any bid not meeting the criteria, that offer of the following bidders will only be accepted. Stop. Paragraph. The petitioners are aggrieved by the same. Stop. It has been submitted that the petitioner that DVC had predetermined the bidders in whose favor the contract will be issued, and that is the reason DVC restricted bidding only to 3 participants. Stop. The said process does not meet the test of transparency, fairness. Transparency and fairness. Stop. It has been submitted that there is no provision mentioned in the RFQ with regard to the eligibility criteria disclosing the financial limits of the bidders who may be permitted to bid in the tender process. Stop. Paragraph. It has been submitted that the entire process is violative of the provisions of Article 12, 14 and 19 of the Constitution. Stop. In support of the prayer has been made to permit the petitioners to participate in the tender process. Stop. It has been highlighted that the petitioners possess the requisite qualification to participate in the tender process. The petitioners are already performing work with the DVC and the NTPC, and the petitioners have the financial eligibility to perform the work. In support of the submission that the tender process ought to be open and not only limited to 3 participants, the petitioners rely on the judgment delivered by the Honorable Supreme Court in the matter of copy reported in Learned Counsel representing the respondent DVC opposes the submission made on behalf of the petitioners. Stop. It has been submitted that the tender process has been kept limited and restricted to only 3 participants due to the policy decision taken by DVC. Stop. Reference has been placed on the proposal for consultancy services for DVC usage of NTPC vendor enlistment. The same mentions that procurement through vendor enlistment is a critical strategy for organizations aiming to establish a reliable and efficient supply chain by ensuring that only qualified and vetted suppliers are considered, the approach of the corporation is to significantly reduce risks relating to quality, compliance, and performance. This DVC has not yet finalized the vendor enlistment process. It has been found that the materials supplied by certain non-reputed vendors are failing frequently, often just after the warranty period. Stop. The failures result in unexpected breakdowns of equipment, which in turn are causing potential power generation losses. Stop. The lack of reliable suppliers is directly impacting the operational efficiency and reliability of the system, leading to increased maintenance costs and unplanned downtimes. Paragraph. DVC found that NTPC, being one of the leading and reputable entities in power generation, procures materials only from enlisted vendors. Stop. They follow a thorough and established vendor enlistment process, ensuring the procurement of high quality materials. Paragraph. DVC proposed to seek consultancy services from NTPC so that DVC can benefit from the vendor enlistment list, which is prepared prior to floating tenders. Stop. DVC has formally requested consultancy services from NTPC regarding usage of their vendor enlistment process for the internal procurement and services of DVC. Stop. DVC communicated their proposal to NTPC, and NTPC in return has provided to offer the requested. NTPC has accepted to provide consultancy services to DVC. The offer is restricted to streamlining DVC's procurement process to ensure that only qualified and reputable vendors are engaged for critical spares and consumables. DVC was authorized to use the available vendor enlistments hosted on the NTPC portal. Stop. It is the specific submission of DVC that the NTPC that from the portal of NTPC, 6 vendors were found. From ki bollam?
Okay, it is the specific submission of DVC that from the portal of NTPC, 6 vendors.
Names of 6 vendors were found enlisted for supplying grinding ball for ball and tube type coal pulverizer. এটা দেখে নেবেন তো। Stop. After the after the financial criteria for the tender was submitted, comma, out of 6, only 3 of the enlisted contractors qualified. Stop. DVC, comma, for the purpose of getting the best services and quality of the materials, chose the 3 members from the said list. Stuff. Next. It has been submitted that it is a policy decision of DVC to keep the tender type within quotes limited and not open it to general public, so that the procurement process remains streamlined within a time-bound manner and also by maintaining transparency. Stop. Next. It has been submitted that the process of limited tenders is in existence for a long period of time, and the same has been approved by the court. Stop. In support of the aforesaid submission, reliance has been placed on the judgment delivered by the Honorable Gujarat High Court in the matter of reported in. Stop. Upon hearing the submission made on behalf of both the parties and on perusal of the documents placed before this court, it appears that that DVC, being the tender inviting authority, has adopted a policy decision to keep the tender process restricted to get the best services of the contractors who already have a proven track record by enlisting their names with the NTPC portal. Stop. The services sought for by the requirement services the requirement of the RFQ is similar to the requirements of NTPC, and the enlisted contractors of NTPC have the experience of providing such type of materials. Stop paragraph. To ensure that there is transparency and fairness in the process, DVC disclosed the names of the three members who were found eligible as per the NTPC portal. The stand adopted by DVC does not appear to be unfair or unreasonable. The company can always take steps to select the best persons who are experienced enough to provide services as per the requirement of the tender inviting authority. Stop. DVC has relied upon the experience shared from the NTPC portal. Stop. The court does not find any infirmity in the same. The relief sought for by the petitioners cannot be allowed in the facts and circumstances of the instant case. The writ petition fails and is hereby dismissed. Service is taken on record.
My lord, if the order can be uploaded today, my lord.
Yes, I'll try my best to check it up and upload it. Yes, because the appeal forum is there and 8th is the date, last date.
9th, they are going to open that.
Yes, right.
8th, lordship.
Madam, I am for the petitioner, madam.
Lordship, I am
Other
for
my
the
lord.
respondent.
13th August, your lordship directed the bank to file a report, my lord. That is, my lord, auction was published, and my petitioner chose and participated and deposited some of rupees 5 lakhs, lord.
Where is the bank? Are you there?
Your Lordship, I am for the bank, Your Lordship.
Yes.
There has been a change, Your Lordship, of the advocate. We have been just inducted, Your Lordship. In this, this is a way back 2014 sale notices were issued. Thereafter, the person who had gone in DRT surface proceedings were initiated. He had filed 3 writ applications. This was initially against Allahabad Bank. Then we merged with them. So, Your Lordship, we have been able to find the DM's order. DM's application that we made before the district magistrate, but the DM's order and subsequent we have not been able to trace as of now. So we were requiring some time to file the report, Your Lordship.
What about the sales? Has the sale been
Your
confirmed?
Lordship, the 3 writ petitions were filed by the person who had gone in the surface. Last writ was filed in 2018, which was disposed of in 2019. So we need to see all the documents.
So from 19 onwards, no steps have been taken.
Your Lordship,
the petitioner submitted all money in September 2014.
Your Lordship,
11 years have passed.
Your Lordship, the DMs for physical possession, the DM.
Who is in possession now?
Your Lordship, we have still not got any information.
Do not know even who is in possession.
Your Lordship, we are trying to. We require some time, Your Lordship, to file the report.
Possession now.
Possession not hand over to me, madam, because I
possession not having handed over.
No, and not sold it as
we had applied before the DM under section 14 on 10th of June 2015. The date was fixed by the DM on 20th July 2015. Thereafter, what orders have been passed by the DM, we need to get certified copies of the same from the DM's office, because
whatever is the cause and the reason, the court is not aware. But September 2014, the price was paid. Even in September 2025, possession has not been handed.
More than 11 years.
Your Lordship, because
because
they had filed writ applications.
No, nothing.
Your Lordship, meantime.
Either return the money or give possession.
Your Lordship,
sale
kindly
certificate.
give me 2 weeks time to take the instructions in the matter, as what steps, where the matter is lying. If at all, if Your Lordship so directs, after that we'll return the money or give the possession, whatever. Give me 2 weeks time to take proper instructions.
Please come. Learned advocate representing the bank seeks further 2 weeks time to revert with instruction. Stop. Positive instruction, that's a positive written instruction shall be taken as to who is in possession of the auctioned property.
Auction put on sale, that is auction. Notice for sale.
And the reason for non-execution of the sale certificate in favor of the petitioner who claims to be the successful auction purchaser and deposited the entire sale price and had deposited 2 weeks. 17th of September.
Obliged, Your Lordship.
Madam, for the petitioner, my lord. That matter, my lord, the post of assistant director, my lord, earlier occasion, my lord, directed to submit the copy of the interview letter, my lord, before the court, my lord. I do not know.
Last order at Lordship was clearly held, my lord, that they should provide the document of his.
But we have
Yes, my lord, they have
sent
seen
him the
interview letter in email, my lord. Email, my lord.
email.
Interview has been held.
No, my lord, it will be held on 11th September 2025.
All right. So the petitioner
Madam, is still doubt, my lord, whether it's a matter of 2018, my lord, whether selection has been completed or not. It is the first, my lord.
interview letter has been given to you.
Yes.
Yes, my lord.
And this is by the PSC saying this. Please
Kindly
enter.
see, my lord, one thing, my lord. The
Learned
recommended, my lord,
advocate representing the Public Service Commission has
kindly see it, my lord.
submitted before this court that the petitioner has been directed to appear for interview. Shukumar Dash. The roll number is telling. Check up, is it the same roll
His
number?
roll number is written. Well, kindly see, kindly see.
This is judicial order. When court has dictated some order,
No, what do you say?
Well, name of the candidates recommended for appointment to 81 candidates, my lord. There is, even there is no date, my lord, in the year. He collected from the net, my lord. He collected from the net that already 81% has been recommended for the appointment. And whether due to fear they are interviewed, my lord.
Due to fear?
Fear of the court, my honorable court, my lord.
So let us see what transpires after the interview.
I'll see this.
Now show it to your learned friend. What is this list that is being referred to?
This is a list for the recommended candidates.
And his name is not recommended.
He was not interviewed, my lord, as per your lord.
So after interview recommendation has been given, so what is the use of this interview?
My lord, that after as per your lordship's order, interview was subject. That petitioner filed the application, and in terms of the application, there are 6 questions wrong, and from after re-evaluation, he got 4 marks. Then he come into the zone of consideration. After that, he is called.
Is still scope for recommending the name of the petitioner?
My lord, if
are vacancies there?
My lord, that will be informed by the state government, my lord. That is not the part of the Public Service Commission. Whether there is any vacancy or not.
Pradeep Likhun, ki bolam? Interview after being found eligible because of awarding 4 extra marks for the 4 extra marks for the wrong questions which the petitioner attempted. Stop. The interview is scheduled on 11th September 2025. Stop. The petitioner is directed to participate in the interview process. And if the petitioner is successful in the same, then necessary consequential steps shall be taken by the competent authority to recommend the name of the petitioner for appointment. Okay? Heat petition stands disposed. This to be taken on record.
Grateful,
Item number 14 I appear for the petitioner. But we had deposited whatever we could have had.
Can you go through this once, my lord? This is the register of the civil copy charge.
What does it say?
Well, now the problem is otherwise. The respondents, the other parties, my lord, says, my lord, that the client has not contacted with them. Not only that, entire record has been destroyed from their end.
There means?
My lord, the petitioner sent. Petitioner of this miss case.
How can the petitioner destroy records? The court records.
There were counter cases. Section 34, section
but
9.
Court's records will be there.
The records are, but the records are not found. That's what, my lord, the registrar wrote a letter to the respondent's advocate and the petitioner's advocate for the.
It is there with me.
Received only photocopies of petitions, summons, and advocate's letter from the learned advocate. No document from the other party and the learned advocate. And this is the other is humbly prayed for necessary direction to proceed with the reconstruction of the records of the learned. If all papers are not received, how can the records be reconstructed? I do not
The papers which we had, those are were office copies.
Is half.
Yes.
What about the others?
Even, my lord, not only that, the arbitrator has died.
Other papers, my lord, with regard to the private respondents, my lord, there.
So, only having papers of one party will not
I understand that. I
suffice.
understand that.
There is another party also.
But I'll humbly pray that my lord, keeps this after vacation. In the meantime, if at all I have any other records with me available, I shall
He cannot
appraise.
because
না না
I
ওদের
think
ওদের
his lordship
ওদের কপি যদি আমার কাছে থেকে থাকে সেগুলো বলি।
kindly takes page 9 once.
Had it been there, you would have given it to
Yes,
the
yes, my lord.
authority.
Much
we have already
page, kindly
submitted
takes
them.
page 9 once, my lord. It has been written to the one of the solicitors, my lord. He has categorically said, my lord, that 2013, my lord. Can you see? Reference to the so-and-so. Please be informed that in the year 2013, we are informed by our client, namely Messrs. So-and-so, that their business have been closed, and in view of the closure of their business, they are instructed for not to taking any steps in the matter.
Why I am pressing this application, because the only anxiety is that, my lord, the only bread and butter of the petitioner has been sold off by the authority, by the private respondents out there, without having any authority in law. It was taken.
You have to take up other recourse that can be done, because you cannot chase back. How far can you chase? I do not know.
Reconstruction, my lord, I do not find any.
Peruse the report of the Registrar, City Civil Court, Calcutta, dated 20th August 2025. It appears therefrom that the registrar received photocopy of the petitions except miss case number 3306 of 2001, page 2, paragraph 5, comma, summons an advocate's letter from the learned advocate of the writ petitioner, but no document from the other party and the arbitrator has been made available. Stop. In the absence of all documents, the registrar has expressed difficulty in reconstruction of the records. Stop. The registrar has, however, indicated that steps for reconstruction may be taken by obtaining records from the learned bench 2 and 8 of the City Civil Court from available unauthenticated copies of the documents so received. The documents submitted by the writ petitioner are also not affirmed documents. Stop. The registrar is permitted to take necessary steps in the matter for reconstruction, if possible, comma, in accordance with law. The writ petition stands disposed.
So very grateful.
My lord, in this matter, I am appearing for the respondent Jila Porishad. My lord, matter has become infructuous. Last occasion I submitted.
Petitioner is there.
My lord, yes.
No, I mean the private.
My lord, he is for private respondent. My lord, what happened, my lord? If your lordship.
1 minute, please. Is the petitioner there?
He is no, my lord. Again, last.
Please for default. Next. Record appearance of all the appearing parties, please.
Grateful.
Lordship, I'm appearing for the petitioner.
Yes.
This is the matter where the fees of Mr. Vikas Singh, a senior advocate, was unpaid by the state.
What has happened?
Lordship, there was a meeting which was held on 1st, day before yesterday. And pursuant to that meeting, certain clarifications have been sought from us. So we are in the process of giving those clarifications. It was only day before yesterday we could not provide. Lordship, and they have indicated their intent to settle. So Lordship, if 2 weeks time can be given, then maybe we can try another one.
Within 2 weeks, can it be done?
Maybe come back after, my lord, because
try to see if it can be done this time, this side of the vacation, at least some positive indication, so the matter can be disposed of. Thereafter, you take steps for payment.
there is all,
a process of reconciliation is also
going
there,
on.
and then there are some stumbling blocks also, my lord.
Yes.
Anyway, if your lordship feels that we should come back
Last-
to this side of the vacation, we'll come back.
At least with some positive instruction so that it can be recorded and disposed of. Or if it is pending, then some positive indication be reflected and then. Acha. Learned advocates appearing on behalf of both the parties submits that the process of conciliation is going on in between the parties. Stop. The parties intend to revert with further instruction on an adjourned date. Stop. 24th, 3 weeks time. The parties are directed to settle the matter prior to the adjourned date.
But can you not direct that one?
Acha, requested.
Please, please.
Acha, na likhun, it is expected that
Yes.
the parties will settle the matter prior to the adjourned date.
Great.
My lord, this is that Apollo matter, my lord.
What happened?
My lord, so far no
Take-
talks have been taken. Talks are going on, my lord, but no. My lord, I would.
How long will talks take place?
My lord, I have at least 2 weeks, my lord. I have talked with the learned advocate general, my lord.
All right.
My lord, kindly give us 2 weeks time more, my lord. May I request, my lord, if your lordship directs, my lord, the state to give a report as to what steps are being taken. Maybe that might expedite.
Whether the writ will be maintainable or not is a question mark. That is the reason the court is trying to see if it can be amicably settled. Otherwise, judicial review in this case, in this type of cases, if it opens up, it will never end.
It will never
It
end.
will never end.
Your lordship, as your lordship.
You are concerned with only one hospital. There are so many hospitals and same things are happening. Very difficult.
I understand the situation, my lord, but
Yes, this is the reason the AG was roped in, only to find out a solution to the
but I
problem.
think the AG is trying hard, my lord, because he had himself assured that he'll ensure
Yes,
some steps are taken.
right.
But I guess, my lord, it's still taking well in the.
Ligun,
Pora nahi re baba.
the matter is yet to be settled between the parties. Stop. Released on 24th. 3 weeks time.
Grateful.
See, yes, no, very good,
Yes, yes.
whatever.
My lord, I think it will be yes, my lord. It will be positive, my lord. I think so, my lord. I'm obliged, my lord.
The petitioner, my
Item
lord.
number 18, Lordship, can you allow me to appear virtually?
Yes, certainly.
I'm appearing on behalf of the respondents, my lord.
My lord, you will
Sir,
kindly
my
call, my
junior
lord.
is there to file the report, my lord, as your lordship desired. My lord, respondent number 3 has prepared the report and it is being submitted.
My lord,
Lord,
this is the matter where my deed of conveyance has been retained by the authorities without any reason, despite me paying the entire stamp and registration duty. It was allegedly retained on the basis of some police case against the ADSR of Guma. Now that the police case has been dropped, now I have requested for them to return the deed. In 3, 4, or 5 other matters, my lord, on the basis of the similar police case, deeds were retained, they have been returned. Now, my lord, I am praying for the return of my deed also.
Lordship, I am not objecting. Lordship, kindly pass the order, my lord, to give them the deeds. We shall deliver them the deeds. Since ban was there from the finance department, that's why you could not. We requested the finance department to remove the ban. It has not yet been done. That's why, pursuant to court order, all the deeds are being delivered. Lordship, kindly pass similar order. My lord, I have no objection.
Why do you require a court's order? If there is no impediment, please return the document.
My lord, ban is still there. That finance department ban. We have requested them to remove the ban, but they didn't yet. That's why, my lord, this is required, nothing else.
You keep a ban in place and in series of matters, the courts are passing orders. What does this mean? What remains of the ban?
Practically, my lord, we have already requested the finance department to, Lordship, kindly come to page 17. We have requested, my lord, prior to remove restriction to deliver deeds of 2006. This is the last application made.
The deeds submitted by the petitioners for registration have not been returned আচ্ছা registration কবে? When 2007? No.
2005, between
2000
2005 and 2006, my lord.
আচ্ছা, in the year 2005-2006. One deed?
No, my lord, four times.
Four deeds of it.
Deeds, ঠিক আছে, have not been returned allegedly due to pendency of a criminal case. Stop. The IGR issued at the time of presentation of the deed is annexed to the writ petition.
Yes, my lord.
All right.
It is in page 19 to 26, my lord.
Pages 19 to 26 of the writ petition. ঠিক আছে? Learned advocate representing the state respondents submits upon instruction that the deeds could not be returned due to the restriction imposed by the finance department. Vide, এই যে, page 4, dated. ঠিক আছে? Stop. Paragraph. Learned advocate for the additional district sub-registrar Guma has filed a report in the form of an affidavit annexing orders passed by this court where where deeds were directed to be returned in similar types of matters. Stop. Paragraph. It has been brought to the notice of the court that the criminal case which was pending has since been dropped and no impediment has been placed before this court standing in the way of the respondent authorities to hand over the registered documents to the petitioners. Stuff. Next. In view of the above, the instant writ petition is disposed of by directing the ADSR, Guma to hand over the registered deeds in question to the petitioners, subject to compliance of all necessary formalities at the earliest, but positively within a period of positively by 26 September 2025.
Yes.
Disposed. Did you get a copy of this?
No, my lord.
Yeah, copy. I handed over.
My lord has observed that subject for formalities. Will
I do not know whether any pending money or anything, all fees paid or not. I do not know.
That has been paid, my lord. I have also annexed my IGR receipts.
Very well. If anything else is required, I do not think much, but then let that remain since so many years have elapsed in the meantime. From 2005 till 25, 20 years. Yes, next.
My lord, this is a similar matter, my lord, concerning a similar deed and the similar ADSR, my lord.
No, my lord,
Same.
last occasion is Lordship is directed to file a fresh report. May I?
Yes.
Here, my lord, the restrictions of the finance department of 2008 is there, and thereafter, my lord, the court has intervened.
So same order can be passed?
Still, my lord, still the finance department has not yet lifted that.
Yes, but the courts are passing orders. That is the reason I was inquiring what is the use of a ban. Only a formal ban. Harassing parties to come to court. Hey, এখানে affidavit টা নেই, but there is a report. Keep it on record. Give a copy to him also. Next.
Grateful, my lord.
This is my application. My lord, on last occasion, my lord, your lordship was pleased to direct the state.
Yes, ma'am.
My lord, to submit the report because my lord, corporation submitted before your lordship that they have sent the requisition for fund. But my lord, the scenario is otherwise. Lordship, kindly have a look to my lord the report. I have received a report, my lord.
UDMA, you are representing?
Yes, my lord.
What
I
did
am
you
appearing
have?
on behalf of the state
on the last occasion, your lordship directing the principal secretary, urban development, municipal affairs to file a report. As per official record, no administrative approval and financial sanction, para 3, has been issued from this department. This is the report, my lord.
Yes.
Yes, sir.
And the work has been executed.
Yes, my lord. And entire matter is pending before the corporation. Last para 6.
That
I have received
Vivek,
copy of the
Yes.
report.
Yeah.
right now, my lord. Lord, may I come back on 17th, my lord, after taking instructions regarding point 4 and 5?
Yes.
My instructions were otherwise.
4, 5 and
You submitted that the request for releasing fund has been
Made to the UDMA.
right.
They said that it was our work.
Yes.
It was conducted by us out of our own accord. My instruction to that effect was otherwise. That's why, my lord, I was praying.
Where is the
That completion certificate is page 14. That was issued by the Milord Executive Engineer Milord.
and you performed the work? Where is the work order? Wasn't it?
Order is, my lord, lordship, kindly have a look to page 13.
Page 13.
My lord, and my lord, in page 14, corporation issued a certificate that this is certified that Dash and Brothers has been completed the work as stated
Was
below.
this floated by the municipality
Yes.
By the
independently?
Yes.
And the UDMA is no way involved?
Yes.
My lord, that is completely, my lord, municipal, my lord,
Yes.
work, because, my lord, they have certified that with full satisfaction under Bidhanagar Municipal Corporation within stipulated period of time, my lord, the agency completed the work. That is page 14. And their, my lord,
Please come.
observation.
My lord, may I
Come back.
Yes, I'll just indicate one thing. In this matter, pursuant to an earlier rounds order, we have passed a reasoned order.
Yes.
The reasoned order, they want to carry out the reasoned order. They have come before this court to carry out the reasoned order. The reasoned order says that all these type of works have been, that page 31 last paragraph. They are not challenging the reasoned order. That and it takes 1, 2, 3, 6 lines from the bottom. It is pertinent to mention here that all these types of works were done with the fund received from the government of West Bengal through Urban Development and Municipal Affairs Department, Government of West Bengal. As such, the Joint Municipal Commissioner BMC is directed to communicate to department. So this is the crux of this matter. The work was done according to the with the funds received from the government.
But the government says it is not.
Yes. 4 and 5. They mentioned my instruction in the matter was otherwise.
Yes, you take instruction.
I come back on 17.
Why 17th, not on 10th?
No, I was praying for 14 days time and I'll come back on 10th.
Well, 10th,
Because-
kindly make it 10th. Because, my lord,
Because
since
again,
2021, he is suffering.
Tomorrow and day after tomorrow are holidays. So I'll only get 2
No, not
working days.
tomorrow.
All right,
Day after
12th.
tomorrow.
12th. A report from the Principal Secretary to the Government of West Bengal,
Principal, Special Secretary.
signed by the Principal Secretary.
Okay, the special secretary.
It's Principal Secretary.
Oh,
Check up.
our
check
copy
up.
is special.
নাম্বার ভুল
Tomorrow
না এটা তো অন্য নাম্বার
the actors.
কি করবো দিয়ে
28119 Das and Brothers.
The special secretary should.
How can the signatory change?
But his copy is also special secretary.
Yes,
This
special
is also special secretary. অন্য কোনো কিছু দিয়েছো নাকি?
হ্যাঁ চেক করে একটু দেখে check up whether it is the same copy that you are relying upon or not.
No, no, it's
Signature is also different.
same copy, principal secretary.
This is also special secretary.
Well, your lords. No, report is same.
No. এখানে 7টা প্যারাগ্রাফ আছে, এখানে 6টা প্যারাগ্রাফ আছে।
Is it in this matter or in which matter?
No, this matter, my lord. This matter on report, your lordship directing the principal secretary with one copy.
All right, give Principal Secretary. You make photocopies or
Yes.
you click pictures and give it to them. Actually, report of the Principal Secretary to the Government of West Bengal, dated 29th August 2025. Filed in court today is written with the records. Stop. Let copy of the same be handed over to the learned advocates representing the petitioner and the Bidhanagar Municipal Corporation. Stop. It appears therefrom that the subject work was undertaken by the Bidhanagar Municipal Corporation out of its own funds. Stop. The Principal Secretary has opined that the liability to clear the dues, comma, if any, comma, to the petitioners will be on the corporation itself and stop. No administrative approval and financial sanction has been taken from the department by the corporation. Stop. No requisition of fund relating to the instant case has been found on records of the department. Stop paragraph. The instruction forwarded by, not instruction, the information forwarded by the principal secretary is contrary to the direction mentioned by the commissioner, comma, Vidhannagar Municipal Corporation.
Yes. Page 31, madam.
Annexed at page 31 of the writ petition. ঠিক আছে? Learned advocate for the corporation is directed to revert with instruction on 12th September 2025. Payment of dues. Matter will appear under the heading payment of dues.
Grateful lords. কপিটা একটু পাওয়া যাবে? কপিটা একটু পাওয়া যাবে? জেরক্স করে দিয়ে দিতে। কপিটা একটু দিয়েছো?
My lord, I'm representing the petitioner. My lord, may kindly remind that the matter is
103 years old freedom fighter.
Yes, my lord.
Wait.
State to produce my lord, the jail records.
Huh.
Apart from that, I'm led by the ASG. My lord, he has requested me to place this matter next week. After taking the subject to lordship convenience, my lord, after 8 except 8. And he will address your lordship, my lord, with regard to the latest view of the Supreme Court on this.
Did you find records?
No records. But I have a report from the jailer.
Give.
আমাকে copy দেবেন একটা। আমাকে একটা copy দিন।
Just my lord, kindly see the my lord, third page. The relevant page is next page.
There is nothing.
My lord,
What do you rely upon? The co-prisoner's certificate? Or petitioner?
yes,
What are you relying upon?
I'm relying upon the document filed at page 28 of the petition. Annexure P4, my lord. Co-prisoners.
When did you first apply for pension?
My lord,
This,
for my knowledge,
yes.
the documents supplied from my client, I have annexed, and he was in custody for 6 months from 12.
The freedom fighters scheme is there for quite a long period of time. Why have you approached court after you have attained century years? What were you doing?
Your Lordship's court, Justice, Honorable Justice Dipankar Dutt's order, my lord, your Lordship sees pursuant to that order, it was disposed of.
Reasoned
After
order has been
11 odd-
passed.
11 years, he has now come up before the Lordship by making a fresh representation to reopen
The
that.
reason order is that
Order was not challenged at that point of time.
My lord, it is at
Page
page
46.
46 of the petition, annexure P7, my lord.
That was.
No, P9. Annexure P9.
46. If it is found to be genuine,
my lord,
we
the
will
dates
give-
has been, my lord, contradictory. My lord, that
But-
was, my lord, in the reasoned order, it has been, my lord, observed.
Genuineness of the certificate was.
Paragraph 4.
It is
Roman.
stated, no.
Non-reliable dates.
That point of time, no report was filed by the
11
state
years.
government.
Yes, come
My
to your
lord.
Lordship, my lord.
Here, your case has been rejected in
Yep.
2014. You have come in 2025. Why?
My lord, thereafter I have given representation on the request.
There is no scope for representation after your case has been rejected on merits.
But,
What can be done now?
it has been mentioned at page 46.
Please come.
The writ petition.
Peruse the report forwarded by the ADG and IG of Correctional Services, West Bengal, dated 29th August 2025, wherein it has been mentioned that despite thorough searches of the jail records, no register containing details of the inmates for the period 12/12/42 to 9/7/43 could be found in the records room of the correctional home. Step. The superintendent of the Tomlug sub-correctional home could not provide any information pertaining to lodging of the petitioner in the prison during the freedom movement. Step. Paragraph. It appears that the prayer of the petitioner for grant of freedom fighters pension was considered by the central government, and with a order dated 29th December 2014, the prayer of the petitioner stood rejected on the ground of non-availability of official records in support of the petitioner's suffering. Step. Swatantrata Shoinik Shamman pension is granted to the freedom fighters who are eligible to receive the same in terms of the scheme. Step. It appears that the petitioner does not meet the eligibility criteria for grant of pension. Step. Next. In view of the above, now the Ministry of Home Affairs considered the prayer of the petitioner and rejected the same by passing a reasoned order nearly 11 years back. Stop. The said issue cannot be reopened in the instant writ petition. Stop. The writ petition accordingly fails and is hereby dismissed.
Grateful to Lord.
I appear for the state
Thank you,
respondent.
My lord,
Good
in this
day,
matter,
Reserve Bank.
my lord, the petitioner had been a prey of bank fraud, my lord, and the petitioner had approached the RBI ombudsman, my lord. Now the RBI ombudsman had rejected the claim of the petitioner without giving the petitioner any hearing. Now, your lordship, since my learned friend appearing for the union was not with any instruction, your lordship directed the union to come up with further instructions in the matter, my lord.
No, submission was that you appeared through the legal representative,
No, my
which
lord, by
you
but
deny.
I denied that because I have shown
Right.
to your lordship the last
Lord, may I hand over some documents?
Yes, please.
Lord, by 4 orders in October 2024, my lord, these complaints were dismissed as non-maintainable. My lord, 3 of the complaints in which orders were passed on 8th October 2024, 21st October 2024, and 23rd October 2024. Your lordship will kindly see in the middle in terms of clause 10(2)(f) of the scheme. Lord, 10(2)(f) of the scheme bars a complaint filed through an advocate unless the advocate is personally aggrieved by any inaction on the part of the bank. So, my lord, in terms of this clause of the ombudsman scheme, these complaints were rejected.
But, my
Lord, in terms, one more complaint had been filed, my lord, which is the last order, Lord, dated 11th December 2024. Lord, this complaint was considered. And Lord, if your lordship kindly turns over the page, Lord, an email on 3rd December 2024 was also sent to the petitioner to participate in the conciliation proceeding. Lord, the petitioner failed to appear, and hence this complaint was also closed by an order of 11th December. So, Lord, 4 complaints filed.
Was the petitioner intimated about the date of hearing?
Lord, that is the email on the last page of 3rd December.
From subject description to Surajit Haldar. Hello.
Buddhadev Mukherjee, my lord.
Yes, yes.
Lord,
My lord,
Email Mukherjee, yes.
my lord, the petitioner's mail address is also there in the complaint, my lord. If my lord kindly turns
Yes, the same mail address this letter has been forwarded.
to that, my lord, I do not have any instruction, but my lord, I have not, as far as my instructions are, my lord, I have
asked in October, my lord, this was filed in April, not disclosed in the petition.
Malad, they have lodged an FIR, Malad. After that, police has conducted an investigation. Police has also found, Malad, who is the accused therein. Malad, police has made a raid, but he was nowhere to be found, Malad. May this report be also kept on record.
and the copy of the communications be handed over to me so that my lord, I can take the
The learned advocate representing Reserve Bank of India relies upon an email communication made by the bank to the petitioner intimating that a conciliation meeting between the complainant and the what is that?
Lord, regulated entity.
Regulated entity is scheduled on 10th December 2024 in the Ombudsman chamber, and the petitioner was requested to attend the same with all necessary documents. Stop. As the petitioner failed to appear in the conciliation meeting, accordingly, the complaint of the petitioner stood closed. Stop. Learned advocate representing the state respondent submits upon instruction received by the Golabari, by the officer received from the officer in charge, Golabari Police Station, Howrah, dated 17th April 2025, wherefrom it appears that in response to the complaint lodged by the petitioner, Golabari PS case number 187/24, dated 15th June 2024, under sections 406, 419, 420 IPC. Was taken up for investigation. Stop. One person by the name of Shahid Sheikh, son of Raju Sheikh, of Ward number 6, এটা copy করবেন তো, was identified and his bank account was found to be involved in the monetary transaction of the instant case. Stop. Notice was issued to the said Raju Sheikh. But the said person did not turn up pursuant to the said notice. Stop. The investigating officer conducted raid at Jamtara, Jharkhand for verification and for tracing out the accused account holder, but he is absconding. Stop. The investigation of the case is reported to be in progress. Stop paragraph. From the submission made on behalf of the parties, it does not appear that there has been any deficiency either on the part of the bank. There has not been any deficiency
Before your lordship closes,
either on the part of the bank or any error
the error is
on the part of the banking ombudsman. Stop. Next. The police is registering the police is investigating the complaint lodged by the petitioner. Stop. The police is directed to conclude the process of investigation at the earliest. ঠিক আছে. The writ petition stands disposed of.
My lord,
Wait for that.
my lord, may closes my writ petition. My lord, may kindly comes on the other day. My lord, I have handed over our RBI rule. My lord, page number 3. My lord, I have a zero for liability. Within 3 days, I have reported to the bank and
They are trying to find out investigation in progress. What can do? What can be done?
The RBI ombudsman, my lord, may open the complaint before the
No,
ombudsman.
no question of opening. And even if he opens, he will not be able to do anything.
But my lord, I have not received a notice.
Please,
My lord,
next.
may only
Wait
grant
for
me a time to follow up with my client, my lord.
Yes.
But this was taken up by your lordship on the last occasion. But this is where my account stands frozen despite there being a direction by the concerned police to unfreeze or defreeze the account. A submission was made on behalf of the bank that there appears to be other such directions in respect of several other investigations that my account is frozen. That they were supposed to indicate, no?
Yes, my lord, I'm filing the report, my lord. There are
Give a
several
copy.
intimation. Yes, my lord. There are several intimation from different police stations, authorities, my lord, for
Same account.
yes, ma'am. Same account, my lord. I have disclosed the documents.
Software Private Limited Company.
My lord, the account number would match, my lord. Can you come to the first document at page 6, my lord?
Yes.
This is from Jyoti Nagar,
We want to do
Delhi,
it today.
Northeast District, Jyoti Nagar, Delhi Police Station, my lord. And the account number, my lord, would find in the first paragraph.
1672 is the last 4
Yes,
digits.
yes, my lord. During the investigation, it was found that duty amount was settled in account number such and such, which is the account of the petitioner, my lord. The bank was instructed to thereafter, my lord, the next document would appear at page number 8, my lord. That is of 19th March email. That is again from a Jyoti Nagar police station. However, here the complaint case number is different, my lord. In the first,
So there are several complaints in respect of the same bank account. Nothing doing.
I'll take 2 minutes. Not
Yeah.
all these are pursuant to appears to be directions of the police, which is contrary to the law. I'll show your lordships a judgment. No.
Yes, please show.
Police cannot authorize or direct the bank to freeze my account. It has to be a direction from the RBI or it must be through a court.
All right.
But in both the orders that are annexed to writ petition, your lordship will find there was an order pursuant to an order passed by the court. And those thereafter the account was directed to be unfrozen or defrozen, and the police communicated that to the bank. The police has no authority to tell the bank. Bank is supposed to be aware of its own guidelines. I'll place it formally, my lord. Lord, this is a division bench judgment of our honorable court.
This is the main judgment. Rina Habiba, এটার উপর rely করে এটা।
আরে এটা কপি দাও রিনা হাবিবা। No, this is a very oft-cited judgment of Rina Habiba, division bench judgment of our court. My lord, bank does not come and indicate, that is important. The bank does not come and indicate they have a banker's lien on this amount, which is not their case. Kindly have a look at this order once.
Yes.
The short grievance of the petitioner, the short grievance of the petitioner is that the bank petitioner deposited certain amounts in a bank account maintained with the respondent bank, but the bank has refused to allow the operation of the relevant account on the basis of specious complaints lodged by third parties. By the judgment and order impugned, the writ noticed that cooperative society and like parties have written letters to the bank that employees of such organizations signed for funds, and the appellant herein was a close relative of one such employees, and the funds parked with the bank in this case may be just stolen money. The writ court took cognizance of such allegation, held that till the disputes as to the nature of the funds deposited at the bank were resolved in appropriate proceedings, no order has been passed on the writ petition. It is elementary that a bank, particularly a national bank, is obliged to follow the commands of its constituent, particularly when there's a credit balance in the account of the constituent. Well, my amount with them in my current account in this writ petition is 12.5 crores. However, if instructions are issued by the Reserve Bank of India, or if orders of coast are passed restraining the concerned bank from allowing a constituent to operate the relevant account, the bank is obliged to follow such instructions or obey the relevant orders. Ordinarily, a bank cannot act on the basis of a stray complaint of a cooperative society or like organization and freeze the account of a constituent. Indeed, in several situations, the bank adopting such procedure is found liable to compensate the constituent by way of damages if checks issued by the constituent are dishonored on presentation. In the absence of any lien being exercised by the bank over the relevant account or the funds lying to the account of a constituent, the bank cannot stop or freeze the account operation of an account. At the very highest, the bank may put the constituent on notice that has received complaints, or the bank may call upon the complainant to obtain an appropriate freezing order from a forum duly authorized to pass such an order. In the absence of the bank either having a claim against the constituent or a lien on the bank account, or the bank being obliged to obey any instructions of the central bank or any order of court, a bank cannot freeze any account of its constituent for any period at all. Ideally, the complainants who had lodged complaint against the petitioner and the related so-and-so, thereafter Lordship will see, in view of such matter, particular serious allegations cannot be appropriately set aside. Respondent is allow the operation of relevant bank account of the appellant. After a period of 8 weeks from date, the bank will forward a copy of this order to any person who may be complained of, can go. And last paragraph, your Lordship will just mark, my lord. If there is no appropriate order from any, at page 3, my lord,
Yes.
from any court of law or like forum, or freezing the relevant account of the appellant herein maintained with the respondent bank within the such period as granted by this order, the respondent bank will allow the free operation of the relevant account by the appellant in no freezing orders obtained relevant bank account. So this is, Mulot, it's surprising that this bank itself does not know its own authorities.
Yes.
Police has written, now your Lordship will have a look at the written instruction. অন্য জাজমেন্টটা দেখাও যেটা আছে এটা ফলো করে
শুনে প্যারা
Mulot, similar,
প্যারা 4 থেকে
Mulot, this was also followed, and may I just cite that, Mulot?
প্যারা 4 দাদা পেজ 2
এক সেকেন্ড দেখিয়ে দিই। Lordship will give me 1 minute, no? Yes, may I just cite this, Mulot? This is a coordinate bench judgment of this honorable court. This was paragraph 3, if your Lordship gives it a cursory glance. This was also frozen without, bank froze without any order from the Reserve Bank or from any order of court. Rina Habiba is relied on in paragraph 4. And then, Lord, I'm not citing Modelo separately, it's referred to in paragraph 5. And your Lordship will just once, Lord, have a look at paragraph 11. Kindly give the rest of it a cursory glance. It's Rina Habiba and Modelo both are referred to here. Paragraph 11, your Lordship will just once please have a look at. Be that as it may I, my lord?
Yes, yes.
Be that as it may, it is evident that there is neither any court order directing freezing of the accounts of the petitioner, nor is there any order passed by any authorized forum in due process of law which can prompt or compel the respondent bank to freeze the accounts of one of its customers, that is the petitioner. The bank itself does not have any claim or lien as such over the accounts, nor has it claimed any such right. In the affidavit also, no such thing, I just checked. Merely at the behest so-and-so, action is palpably illegal, unauthorized. But if banks take such recourse to action in future, it would erode the confidence reposed in bank by the customers. In view of such observation, the impugned action of the respondent bank in debit freezing the account of the petitioner in question so-and-so. Now, my lord, if I just take your lordships once back to the affidavit that they have filed, your lordship will not find that page 6 and page 8. There is absolutely no mention of any RBI naturally direction or any court order. These are issued under, to much of my surprise, under section 91. I have 12.5 crores in my current account. The bank is being sent 91 notices of CRPC and bank freezes my entire bank account.
Yes.
And there is absolutely no, the affidavit doesn't say there's a banker's lien on this amount. So one random person goes and files a complaint. Now your lordship will see page 6. Just the malafide of how things are happening here. First paragraph, last sentence. Now the complainant felt someone has cheated with him and wants legal action against the accused. During investigation, it was found that cheated amount was from settled in account number so-and-so. And this is given on March 9, 2025. Lord, if I can really, no, I'm sorry. This is dated 30th of July, 2024. At the top at page 6, your lordship will find. So 91 notice under CRPC, 31st July 24, ostensible defenses, there's an order by police. No order of magistrate is given. And my 12.5 crores will stay frozen by the bank. On the ground, police is writing that some complainant has felt that he's been cheated, and I am not the accused. I am not an accused in any of this. Well, this, in terms of my Lord Justice Bhattacharya's order, this really erodes my confidence in my banker.
Yes, anything else?
Look, one more aspect your lordship will see, all these subjects, all these notices are July 24, one is December 2024, and all of them are from police. It's neither the competent forum issued in accordance due process of law,
please come,
nor this. Look, may I just make one friend? In the unlikely event that your lordship is not with me, and this freezing order is allowed to remain, may I secure with the bank whatever money is the subject matter of whatever these complaints are. So the remaining bit of it, kindly allow me to use it. 12.5 crores can't get stuck for 2.5 lakhs of complaint, my lord.
A report in the form of affidavit.
Complaints, the letters
There are 3.
bank has received. No,
A report in the form of affidavit filed by the ICICI Bank. In court today is taken on record. Stop. The petitioner prays for defreezing the bank account, which stood frozen by the bank upon instruction from the police. Stop. Specific submission of the petitioner is that the police does not have any authority to direct the bank to freeze the bank account of the petitioner, which has a balance amount of nearly 12.5 crore. Stop.
Can you just give me the citations? I will take.
The judgment delivered by this court, by the Honorable Division Bench of this court on 7th January 2020 in FMA 74 of 2020, please set out, has been relied upon in support of the submission that ordinarily a bank cannot act on the basis of a stray complaint of a cooperative society or like organization and freeze the account of a constituent. At the very highest, the bank may put the constituent on notice that it has received complaints, or the bank may call upon the complainant to obtain an appropriate freezing order from a forum duly authorized to pass such an order. Stop. In the absence of a bank either having a claim against the constituent or a lien on the bank account, or the bank being obliged to obtain any instructions from the central bank or any other order of court, a bank cannot freeze any account of its constituent for any period at all. Reliance has also been placed on the order dated 10th May 2024, passed by a coordinate bench of this court in WPA, set out. Wherein the court held that without any court order directing freezing of the account of the holder, without any court order or any order passed by any authorized forum in due process of law, directing freezing of the account of the holder, the bank ought not freeze the account of one of its customers. Account of its customers. Prayer has been made to direct the bank to defreeze the bank account, or in the alternative, direct the petitioner to submit security before the bank, relying on which the bank may permit the petitioner to operate the bank account. Paragraph. On a perusal of the affidavit filed by the bank, it appears that in respect of the bank account of the petitioner, there are several complaints pending and intimation sent from different police stations for freezing of the account. Stop. Notices issued under section 91 CRPC in response to the complaint lodged against cheating and unauthorized transactions কি বললাম? Are annexed to the said report stuff. The police has mentioned in the said notice that the amount cheated was found to be settled in the bank account of the petitioner. Stuff. The details of the FIR number are also disclosed in the affidavit stuff. It appears that NDPS case where the bank account of the petitioner has been found to be involved is also disclosed in the affidavit. The figures involved appears to be of higher denomination. Stuff. The paragraph, though the learned advocate representing the petitioner submits that relying on a complaint from a person, from a complainant, the bank ought not to freeze the bank account as held by the court in the matter of Reena Habiba within bracket Supra and Dr. Sunip Banerjee within bracket Supra. But in the instant case, request has been made by the police, which is the competent investigating agency, in response to a complaint lodged. Stuff. The request to the bank for freezing was not made by any complainant directly, but by the law investigating agency. Stuff. The account of the petitioner was found to be involved in several fraudulent transactions. Stuff. The police are investigating the case. Stuff. The proceeds of crime may be parked in the bank account of the petitioner. Stuff. The dealings under the NDPS Act were also found to be involved. Stuff. It will be highly improper to direct the bank to defreeze the bank account after noticing the several complaints lodged against the bank account maintained by the petitioner. Stuff. The as the details of the case pursuant to which the request for freezing was made by the police are made known in the, not made known, but disclosed in the affidavit, comma, it will be open for the petitioner to approach the competent forum for obtaining order for defreezing. Stuff. This court is not inclined to exercise jurisdiction in this matter. The writ petition fails and is hereby dismissed. Next.
Great. Take a chance to redeem myself immediately.
No, no, last occasion, my lord, I have raised the maintainability point regarding the territorial jurisdiction. Your lordship was also satisfied on that point. Due to the prayer of my learned friend, my lord, to submit the supplementary affidavit for this decision matter was acted. And I have also submitted one recent decision of your lordship.
Supplementary affidavit is already on record.
That was filed, my lord.
Did you not get a copy?
Yes, yes, I have.
Got yourself a copy. Yes. Why territorial jurisdiction?
My lord, kindly see the
Oh, Madhya
cross
Pradesh.
title of the
Madhya Pradesh. Everything arose within Madhya Pradesh.
out of my lord, the
Yes.
not only that, every communication was also held at that. My lord, kindly come to the page
Let
80,
me hear. Let me hear the petitioner.
81, 89 and 103.
Let me hear.
Not, I supply goods to the railways. The railways, after the period of supply, has sent it to different consignees. Those consignees are spread across the country. Now, these consignees have later, beyond the period, rejected these goods. These goods have to be rejected in terms of the agreement only after inspection. My primary prayer was that this could not have been rejected without actually affording me an opportunity of inspection along with the railways. Lord, pursuant to your lordship, pursuant to this order, my lord, we've received a letter from the railways on 28th of August 2025. Eta ka? May I just hand that over, my lord? I think this will be, we'll be able to cut short the matter with this. उधर ही तो चिट्ठी 28 अपना ही तो चिट्ठी 28th August 2025 your lordship will see this is being written regarding subject joint
This is being written to rights.
Yes, rights is the that was our case. The rights is the inspecting agency under the contract. When I'm supplying, this is also given to copy to me, but when I'm supplying, these are pre-inspected goods. Rights inspects it, then we supply it. So post-supply for pre-inspected goods, you cannot under the particular circular, you can't without inspection by a tripartite inspection, you can't reject. So now they have in principle agreed by this letter of 28th August, where the respondent is writing two rights with a copy marked to me, serial copy to serial number 6, your lordship will find the name of the petitioner. In reference to the above, purchase order was issued so and so. Ganpati for manufacture and supply of total this number joined with third party inspection of rights. Accordingly, firm supply a full quantity of so and so consignee 3rd January 23 to January 24 under centralized procurement. Inspection of these glue joints was done by rights. Western in these glue joints were distributed to different field consignees of WCI. As per field reports, the premature failure of glue joint has been reported and accordingly voluntary rejection claims to have been initiated. In response, firm raised request for joint inspection. Accordingly, firm was advised to do joint inspection with field consignee. However, the firm has not agreed to the inspection with the railway's ultimate consignee and has insisted on conducting the inspection with rights Mumbai and the ultimate consignee. Therefore, you are requested to kindly depute a representative for the inspection of premature filling of 60 glued joints. Please intimate name of inspector and date for joint inspection against location mentioned ISIS one. But now they've agreed to this. Lordship will direct rights as a party through.
Rights is not a party.
Oh, amazing. Well, in terms of this, the inspection can be held and a report can come before this court.
Why before this court? If they have principally agreed to inspect, let them proceed further.
No, my substantial challenge is to the warranty rejection advice. Well, without what they're doing is this is a post decisional inspection. The challenge is now they've understood that under the RDSO circular they could not have actually rejected it without a tripartite inspection because these were all pre-inspected goods. So even whatever happens, if I today the writ goes, my warranty rejection advice is going to stand.
Yes.
So let this inspection happen and lordship keeps it not after that if we can.
By this way, the scope of the writ petition gets expanded.
No, this is the scope of my writ petition.
The issue of maintainability also goes. So without entering into anything, if the railways have thought it fit to direct rights to conduct an inspection, let them inspect.
Let this entire process be done. In the meantime, let them not take any coercive steps in respect of within a certain period of let this be done. In the meantime, in respect of this voluntary rejection advice, let them not take any coercive steps. And within this period, let this be done. But otherwise, I'll address your lordship on the his only point of maintainability is 226(2). That will not, I'm covered by decision passed by this honorable court, by decision passed by this honorable court, division bench, I'll be able to satisfy the court on that. Otherwise, your lordship will consider disposing of on the basis of this letter, because I really thought post this.
I can dispose of on the basis of this letter without entering into merits of any of your grievances, your claim, anything in the writ petition.
But Manoj, in the
So that
meantime, if they
you cannot say in the next litigation that the court entertained the petition, writ petition was open. Maintainability issue? No.
No, then the only difficulty, I don't want to shy away from the point of 226(2), but my only difficulty is that while they undertake this exercise, which they agree ought to have been done now, or at least before, they'll deduct the money that is involved. So restrains them from doing that within a certain period of time. If this exercise can be conducted in 4 weeks' time, because now we know where the 60 glue joints are.
What is your submission? Are you aware of this?
Regarding this, my lord, just first time, my lord.
Your client didn't intimate you that this has happened in the meantime?
No, this is the first, my lord. What I have learned, kindly come to the page 47, my lord, of the supplementary affidavit.
No, after the supplementary affidavit, this has come in.
Yes, my lord. Just now, my lord, that I have seen, my lord, I have also copied, was handed over to.
Yes. আচ্ছা আসুন তো দেখি। A communication dated 28th August 25 by the General Manager's Office, Engineering Department, Jabalpur, addressed to the Group General Manager within bracket inspection, Rights Limited.
My lord, one thing, my lord.
For conducting joint inspection,
My lord,
you go on submitting, I can hear.
No, my lord, I have last occasion I have tender documents I have also submitted, wherein, my lord, at clause 7 that the jurisdictional court is also, my lord, stated, my lord.
Yes. কি বললাম?
For conducting joint inspection.
Contract outside 226.
With the firm for the warranty rejection claim. কি বললাম?
For conducting joint inspection with the firm.
For warranty rejection claim stuff. Rights have been requested to depute its representative for the inspection. The name of the inspector and the date of joint inspection against the locations mentioned in the annexure to the said communication have been requested to be intimated to the Railway Authority. Stop paragraph. From the aforesaid, it appears that the railways have agreed to cause an inspection of the goods which were found to be defective. Is it defective or what? Is the good found?
That's the allegation.
Defective.
Yes.
Found to be defective. ঠিক আছে? Stop. It will be open for the petitioner to take part in the process of inspection and point out necessary facts. Stop. The writ petition stands disposed of. Stop. It is made clear that the court has not entered into the issue of maintainability of the writ petition. Stop. If the allegation of the petitioner that the goods were defect free appears to be proper, then necessary remedial steps shall be taken by the railways.
Lord, in
Disposed.
the meantime, your lordship will stay their hands from deducting the money, my lord. That is my writ petition. Otherwise, I'll address your lordship on 226 too. My lord,
Suppose they ultimately find that it is defect free.
yes, Lord, I have to file a suit for recovery of that money. Now with
In the writ
railways,
court.
is there, Lord, lordship will set a timeline within which they'll do it.
Acha. Steps shall be taken for inspection at the earliest, but positively within a period of how soon does it take? How long does it take?
At the most, 8 weeks হবে তার থেকে বেশি তো নয়। At the most 8 weeks, the rights will go. We know why the
At the earliest, but positively within a period of 8 weeks from the date of communication.
8 weeks.
Then it's all right.
But not to deduct the money in the meantime, Lord.
No,
Otherwise-
this.
Otherwise, my lord, the entire purpose of
Acha,
it.
any deduction, deduction if any made.
Getting reduction money.
Deduction if any made. Deduction of what?
They're deducting money from other contract. That your lordship
my
will
lord.
stay their hand for 8
No, my
weeks.
lord,
That's
that is-
no advice.
Deduction
My
of
lord, specific clauses is there in the contract, my lord.
You
My lord,
can't, there's
no, my lord, for this reason, my lord.
a
Kindly hear
deduction
me
of
for a
any
moment, my
money
lord.
from the account of the petitioner, if any made, shall be subject to the fate of the inspection.
Great. Your lordship, please to dispose this off, no?
Yes.
This matter is similar to batch of about 6 matters that we've done before your lordship, where a consortium of bank lenders had lent me certain amount of money. Not the entire consortium has declared my account as a fraud and me as a fraud under the fraud circular, master circular. 6 of them have been set aside, my lord, by your lordship. This is the 7th one. This is the 7th one. Not the identical facts, identical situation. 2 facts I'll indicate, my lord. I understand your lordship's order. My lord wanted to see the similarity between the other writs and this.
Because this is what the submission of the bank was, that this is different.
Irrelevant. Let me just take it that this is completely dissimilar. I will just address your lordship on the issue of law that can't change.
All right.
And on the issue of committee of courts.
All right.
2 facts,
But
my lord,
then,
your lordship.
if it has to be heard, it cannot be done now.
But it was your lordship has been pleased to set it aside on the first day. I'll take exactly 5 minutes. It's just on a question of law, whether I have to be heard before an account or before I am declared as fraud under the circular. That's covered by your lordship, relying on a Supreme Court judgment. Second, if a show cause notice, if it has been issued under the circular, you have to give me all the relevant particulars and documents which you've relied on. That is also covered by your lordship judgment, relying on another coordinate by judgment of this honorable court, that if you have not given the document, then that show cause can't sustain. If you haven't given a hearing post the show cause, then the declaration of the account or of the borrower as a fraud cannot be sustained. That's the requirement of the master circular. 2 facts, your lordship needn't even make a note of, just the RBI guidelines at page 349. Don't make a note of anything. Not just only one thing your lordship will make a note of, that the show cause notice was issued to me on 27th of October 2024.
Yes.
21st of October 2024. And that is at page 202. And the order of declaration of the account as fraud has been passed on 24th of March 2025. This one show cause thing I'll just show to your lordship at page 202. Please have a look at it once.
Yes.
You know, 202, your lordship will find the show cause notice. Lord, it refers to a host of sums, figures, particulars. Please give it a cursory glance because there is no difference between the show cause and the ones that have been issued. Your lordship will not find a single document that is mentioned. Your lordship will not find that the forensic audit report is also mentioned in this. These were not given to me at all at this stage. Now, my lord, I have given a reply to this that your lordship will find at 210. Here, your lordship will find I have specifically taken the plea and I've asked for the documents. I've asked for a hearing in terms of Supreme Court judgment at page 212. If my lord turns over, my lord,
Yes.
at 214.
Yes.
Now, I, without prejudice to the above, it is submitted that your notice under reply is absolutely contrary to guidelines, date of marking of red flagged account, date of classification, disregards all this, my lord. E, your lordship, D and E, your lordship will kindly have a look at once. What at 215? What are those documents which are stated to have been examined by your committee before coming to a conclusion that there is a suspected fraud in the account? What documents or records have been examined by your identification committee to conclude that the company has diverted funds? And I, if your lordship kindly has a look at, my lord, D to H are all asking for documents. And I, your lordship, will see copy of forensic audit report. Now, the copy of the forensic audit report was given post this. My reply and no hearing given. My lord forgets any similarity of fact. I don't need to do it. I'll cite this as a binding precedent. My lord, your lordship will just have a look at it. Simplicity. No. Lordship will rate a point. My lord, this banker is Bank of Maharashtra. This consortium lead banker was Canara Bank. The Canara Bank's fraud account, Mr. Ratnankur Banerjee was appearing against such. Your lordship will remember it was a threadbare, very long hearing that was done before this court. I am formally citing it, my lord, for the sake of completeness. This is the 18th March 2025 order. Okay, copy that. Nishchay Janbi. Lender Bank. 2, your lordship will see, paragraph 2. The primary ground for challenge is that the show cause notice does not disclose the basis relying on which the authority sought to declare the account of the petitioner as fraud. The documents relied upon by the bank to arrive at a conclusion that the petitioner's account is declared as a fraud were neither forwarded nor disclosed. The forensic audit report relied in the show cause notice was not forwarded prior to issuance of the notice to show cause. Opportunity of hearing was not given to the petitioners prior to final declaration of the account as fraud. Then I cite Rajesh Agarwal, my lord. Then Shweta Agarwal is considered. That's the coordinate bench judgment of this honorable court. Then Mr. Banerjee's arguments are recorded. Your lordship will kindly now please have a look at paragraph 11 onwards. From the documents annexed to the writ petition, it is evident that prior to issuance of the show cause notice, there had been several communications by and between the parties. Admittedly, repeated opportunities were given to the petitioners to provide information based on the auditor's report, but the show cause notice issued to the petitioners did not disclose the documents and the details relied upon by the bank to declare the petitioner's account as fraud. The parties may have exchanged several communications, but the exact communication, the proper fact and figure which the petitioner relied upon for concluding that the petitioner's account is fraud has not been disclosed in the show cause notice. The contention of the bank that as all details were known to the petitioners, accordingly there was no requirement for disclosing each and every fact all over again in the show cause notice cannot be accepted by the court. A coordinate bench of this court in Shweta Agarwal held that before declaring an account as fraud, the documents relied upon by the committee should be mentioned in the show cause notice and also be supplied to the borrower. As regards the opportunity of hearing, this is my other point, my lord. As regards the opportunity of hearing, the Honorable Supreme Court held that the borrower should be given an opportunity to explain the conclusion of the forensic audit report and be allowed to represent the banks before their account is classified as fraud. The stand of the bank that as there was no request for personal hearing, the same was not allowed, does not save the order passed by the bank declaring the bank account of the petitioners as fraud from the vice of arbitrariness. There was no question of requirement of the borrower for seeking such a hearing. The Honorable Supreme Court in Rajesh Agarwal has held that the principle of ori alteram partem has to be read in the master directions on fraud. It was obligatory for the bank to provide the opportunity of hearing to the petitioner.
Yes, I've got it.
One last fact, my lord, that this is issued in the matter of Canara Bank. It is an admitted position that this respondent is a part of the consortium of which Canara Bank was the lead banker. This order is 18th of March 2025. The lead banker has accepted this position in law. There is no appeal that Canara, the lead banker, has filed. It doesn't matter that it's Canara Bank. The fact that it's a lead banker of a consortium having accepted it, today another member, apart from this being binding on him too, can't take a different stand. And thirdly, my lord, just on the issue of this.
Where is this order?
Yes, my lord, this your lordship will find is at page 347. 347, please have a look at it once. You know, this would have been the third point that I would have urged before your lordship.
Yes.
This is dated 24th March 2025. You know, there is no iota of reasoning. And the master circular requires that you have to provide reasons for declaring. I'll show that one particular thing, no, 348. Please have a look at. Accordingly, the bank has decided to classify reasons for fraud angle, bullet points. These are all conclusions. Your lordships have time and again held the reasons are the heartbeat of a decision.
What is your submission?
This, can I get 30 more seconds? Can I just show to your lordship this one particular aspect of the RBI guidelines? Page 349, your lordship will kindly have a look at once.
Yes.
That it must be accompanied with reasons. At page 353,
yes.
Yes, my lord, 353, it starts at governance 2.1.1.4.
Yes.
A reasoned order shall be served on the persons stroke entities conveying the decision of the bank regarding declaration or classification of the account as fraud or otherwise. Such order must contain relevant facts, circumstances relied upon, the submission made against the SCN, and the reasons for classification as fraud or otherwise. Nothing mentioned in the impugned order. Well, these are my respectful submissions.
My lord, on the last occasion, my lord was pleased to direct me on two issues. I need to take instruction and to make submission before your lordship. One, with regard to jurisdiction, my lord, kindly do not record my consent, but to be candid to your lordship, I am not raising any issue on with regard to territorial jurisdiction, but kindly do not record my consent there. Now, my lord, with regard to merit of the matter, if your lordship kindly be pleased to come to at page 202. That is the show cause notice.
Yes.
Well, the body starts at page 203.
Yes.
Nature of the loan for credit facility, etc. Paragraph 2, paragraph 3, my lord. We refer to the RBI master directions on fraud management dated July 15, 2024, based on which we have suspected some fraudulent activity in your account in respect of nature of fraud, misappropriation, trust, etc. Based on the forensic, then my lord, paragraph 5, based on the forensic audit report, the reasons for observance of the account as fraud is as under. My lord, it is a longish letter. My lord, I am not wasting your lordship's time. In details, my lord, I have alleged the basis for which I am suspecting this account to be fraud, and he should satisfy me why this should not be treated as a fraud account. My lord, kindly comes to page 208, paragraph 9 at the bottom.
Yes.
Before that, my lord, there are detailed instances why this account should not be treated as fraud.
Listen, the court is not going into the merits whether it is fraud or not fraud. The court is only concerned whether there is
that is why, my lord, I did
violation of principle of natural justice, whether the RBI circular has been followed or not.
Absolutely.
Assuming the court sets aside the entire process, it will leave it open to you to
know, my lord.
restart it afresh in accordance with the guidelines.
Earlier orders. I followed from my lord earlier order, and that is why, my lord, I did not place the entire list.
Yes.
Because I have to satisfy, my lord, only with regard to the modalities that I have.
No, what is the difference? See, already there is an order governing the field. What is the difference between the two? If there is no difference,
I am too late in making the submission because by this time around 6 or 7 orders has been passed by the court with regard to this particular account.
And
but
no appeal has been preferred.
But for my satisfaction, if your lordship kindly be pleased to take 2 orders, what my lord has already been pleased to look into on several occasions. This is, my lord, this is the Rajesh Agarwal, this is the order passed by the Honorable Supreme Court after the detailed order that had been passed.
This is the clarificatory order which your lordship has seen in the first one.
Yes.
Now, if your lordship kindly be pleased to come to paragraph 2. While upholding the judgment of the High Court at Telangana dated such and such, the operative direction of this court are those which are summarized in paragraph 81, section E of the judgment. Now, only one paragraph, my lord, kindly be pleased to look into. Paragraph 81. Main order. Audi alteram partem therefore entails that an entity against whom evidence is collected must be provided with an opportunity to explain the evidence against it, be informed of the proposed action, and be allowed to represent why the proposed action should not be taken. Hence, the mere participation of the borrower during the course of preparation of the forensic audit report would not fulfill the requirements of natural justice. The decision to classify an account as fraud involves due application of mind to the facts and law by the lender banks.
The lender banks, either individually or through a JLF, have to decide whether a borrower has breached the terms and conditions of a loan agreement, and based upon such determination, the lender banks can seek appropriate remedies. Therefore, principle of natural justice demand that the borrowers must be served with a notice, given an opportunity to explain the findings in the forensic audit report, and represent before the account is classified fraud under the master directions of fraud. So, my lord, if I may take, subject to correction by your lordship, that my responsibility to allow him to make sufficient representation. Now, what they have asked for. If your lordship kindly be pleased to take the reply to the show cause notice. Page 210.
Yes.
Paragraph 1, he says that he has to place certain vital facts. Paragraph 2, 3, kindly come to paragraph 4. The company has repeatedly requested for holding operations in their account since September 15, 2023 on multiple occasions. However, these requests have been ignored, and the lenders, including your bank, have not provided any satisfactory explanations for the same. After 3 to 4 months, we were allowed to make statutory payments only, and other payments were not allowed. Then, my lord, paragraph 5. Company has already provided all the relevant draft information to professionals appointment by your bank, like forensic auditors, LC and IBG auditors, and to the best of our knowledge, there have been no requirements or as such that are pending at our end. My lord, kindly take note of the first line of the sentence. Company has already provided all the relevant data / information. So the data and information, those were lying with the auditor. Why lying with the company? Why I say so, my lord, I'll come to that. Then, my lord, kindly, paragraph 6, they are giving their preliminary reply. They, small Roman 1, they are relying on the Rajesh Agarwal thick judgment. Then, my lord, small Roman 2 at page 214. Without prejudice to the above, please note that pursuant to the passing of the aforesaid judgment by the Honorable Supreme Court, Reserve Bank of India superseded its earlier guidelines dated 1/7/2016 and issued a fresh detailed guideline dated 15 July 2024, wherein also RBI has substantially directed the bank to follow the principle of natural justice, which must be strictly followed, and as merely illusion should not be created as to following principle of natural justice, which has been done by your bank in their incomplete notice under reply. Without prejudice to the above, it is submitted that your notice under reply is absolutely contrary to the guidelines of 2024 for the reasons before issuing the notice under reply. Following imperative details have not been provided. A, date of red flag account. B, date of classification of our accounts of NPA. C, name and designation of the officers of the bank who form the committee to examine the documents relating to the accounts. D, what are those documents which are stated to have been examined by your committee before coming to a conclusion that there is suspected fraud in this account? E, what documents or records have been examined by your identification committee to conclude that the company has diverted funds in respect of payment? F, what are the records or documents?
Anyway, do not read. These are the queries.
These are his allegations. Now, why I say that this is important? Now, kindly take 2 communications, one by Canara Bank, 27 December 2023, and the later dated 20th January 2024. Between Canara Bank as the lead banker and 27 December or 20th.
So why do you want to rely on these letters?
Kindly please to take Canara Bank's letter once.
Why? Do you say why?
The documents are all lying with the company. It is the company who had to provide that auditor, who had to provide the documents so that the forensic audit could be conducted. Now, my lord may be pleased to find, since I am in motion stage, my lord may be pleased to find that there are at least 10 series of communications where the auditor is raising his allegation. Please give me the documents so that I can conclude the forensic audit. The company is saying.
So you say because of the non-supply of documents by the petitioner, there has been delay in preparing the forensic audit report. Yes.
That is one.
Right.
Then, when it is at that stage, company never denied that it is not liable to give the documents. Company said, I need some time. There are some technical glitches. My lord can take it from me. It is part of other writ petition. There are some technical glitches, so I cannot provide it right now, but I will provide at some point of time. So it is not the case that the documents were not lying with the company.
Relying on which document did you declare the petitioner as fraud? Was this made known to the petitioner? And was these documents handed over to the petitioner? This is the query of the court.
Absolutely,
what documents the petitioner had is not the issue.
Absolutely.
The petitioner may have a variety of documents in its records. See, without wasting court's time, the lead banker of the consortium of banks has already been passed this order.
Yes.
You are one of the member of the said consortium. Same identical allegation of fraud. You start steps afresh so that you can get hold of the petitioner.
I thought, since that matter has been argued by Mr. Banerjee, definitely I'm not in a
Whoever
better
is arguing is not important. If you
and
feel
it is
that
the
there
lead
is-
banker. I have to accept it is the
Right. Then why are you making this
but
submission?
I believe that the documents that have been mentioned and the situation that had been mentioned in the show cause notice. If your lordship kindly permits me to go through the show cause notice, that will take a lot of time.
Not only lot of time, that is going to delay you in starting fresh proceeding for fraud.
I understand, but since it is from I am already after around 8 or 9 months from October 2024. My lord, kindly allow me another week to
No further.
give it a
Please,
try.
this is
Then my lord, kindly
adjudication.
look into the show cause notice once.
No, I have seen that. Achha, the petitioner is aggrieved by the
Kindly only one
order.
sentence. Paragraph 5 of the show cause notice at page
Holding the petitioner as fraud.
203, paragraph 5.
Dated 24th March 2025 by the Bank of Maharashtra. The subject bank is a member of the consortium of banks where the Canara Bank is the lead bank. Similar order of fraud was passed against the petitioner by the Canara Bank, which was under challenge before this court in WPA 29044 of 2024. Set out the cost title. The court, after hearing the parties in details, passed order on 18th March 2025 by setting aside the show cause notice and the final order declaring the account of the petitioners as fraud. So the court granted liberty to the bank to take steps in the matter strictly in accordance with law. Paragraph. The lead banker of the consortium did not take any steps to assail the order dated 18th March 2025 before any superior forum, and by now the said order has attained finality. The grievance, paragraph the grievances of the petitioner in the instant writ petition are more or less similar to the grievances in The matter of Canara Bank, within bracket Supra. Stop. The violation of the principle of natural justice and action taken by the bank contrary to the law laid down, contrary to the direction of the Reserve Bank of India on the guidelines of fraud and the law laid down by the Supreme Court, have been argued by the parties. Stop. According to the bank, the petitioner deliberately delayed in submission of documents for which there has admittedly been delay in preparation of the forensic audit report. Stop. The bank contends that all documents and relevant details were with the petitioner. Stop. Paragraph. It appears that the same grievance, now the same point raised by the bank was considered in the matter of Canara Bank Supra, and the court passed necessary order. Stop. The court is of the opinion that the bank would be obliged to forward to the petitioner all relevant documents relying on which the bank account of the petitioner was declared as fraud. Stop. The from the documents annexed to the writ petition, it does not appear that the documents sought for by the petitioner to give a meaningful reply to the show cause notice served upon it were supplied to the petitioners. Stop. Next, in view of the above, the final order declaring the account of the petitioners as fraud is set aside. Stop. It will be open for the bank to take steps in the matter strictly in accordance with law. Writ petition disposed.
Good. But only one thing that
Yes.
you will just bear with me for 30 seconds. huh?
এগুলো সব ফেরত দিয়ে দেবেন। Yes, please.
But in the previous set of all the writ petitions, your lordship was pleased to set aside the notice to show cause also. But here your lordship only set aside the order. The show cause notice was also found folly of the Reserve Bank circular because it did not provide all the particulars and the documents. Which is why on that analogy, your lordship has set aside the show cause notice. I'll be renewing my prayer, my lord.
Here also the show cause notice does not
Nothing. No mention of any, nothing. No document, no forensic audit report, does not give me an opportunity of hearing.
My lord, in
forensic
paragraph
audit report has been
5,
forwarded later on to you, you say?
Well, it's the same analogy. Well, that Canara Bank, that Canara Bank matter, which I am relying on now, there, or this same reason, the show cause will also set aside.
Right now, the forensic audit report has been forwarded to you.
Post the hearing, but your lordship has set aside the show cause notice.
Right, but you have the forensic audit
Yes,
report, so that has the details.
No, my lord, not your lordship's specific finding was that all documents relied,
Yes.
including forensic audit report.
Right.
That will have to be given because it does not provide the show cause notice will also incorrect. And because in the show cause, your lordship will have a look at the Canara Bank judgment, my lord. Because in the show cause, my lord, there was no opportunity of hearing that was granted. The show cause was also set aside. May I just place it once, my lord?
No, as opportunity of hearing was not granted according to the final order is set aside,
Yes.
that's all right. But
And
why will the show cause go?
Because none of the documents were given in the show cause notice. Forensic audit report, post-decisional hearing in every matter we got. Even in this one, your lordship has recorded. I'll just place that line, my lord. the forensic audit report relied on in the show cause notice was not forwarded prior to the issuance of the show cause notice.
Yes.
It was on this
here
ground that
also
your
it
lordship
was-
set aside the
ঠিক আছে তাহলে ওই শোকজ নোটিশটা সেট অ্যাসাইড করে
2.1
দেবেন তো লাস্টে যেখানে ফাইনাল অর্ডারটা বললাম না order declaring fraud set aside
For order declaring the accounts petition as fraud is set aside.
তার আগে the show cause notice and the
এই জায়গাটা
add হবে
review আগে
না
review of the past
থাকবে
থাকবে
হ্যাঁ
তার আগে
তারপরে যেখানে ফ্রড বললাম ঠিক তার আগেই
আচ্ছা
এইখানে দেখুন একটা অর্ডার অলরেডি আছে এখানে একটা অলরেডি অর্ডার আছে
Lord, I have a
will be open এর পরে এই যে
My lord, I have a reply to this only.
So the affidavit of
Only,
service.
only one sentence.
service taken on
This
record.
show cause notice was issued on 21st October 2024, and they have the forensic audit report as it has been admitted in the other writ petition.
Later on. Here also
No,
later on.
June 2024.
No.
Yes,
It was given to me
yes,
on
yes.
In this case, it was given later on, isn't it?
26th
No,
December.
no,
And
no.
no key on from records is
My
there.
lord,
Some other bank has got it.
WPA 2128, they have admitted this.
That the forensic audit.
That has also
In
been set
June-
aside.
June
Assuming forensic
2024.
audit report, but other documents were possibly not.
No, I have relied only
Because
on forensic audit report.
A host of
I have
other
relied on-
papers the petitioner saw.
I have relied only on forensic audit report in paragraph 5.
It cannot be only forensic.
Well,
There
that-
must be other documents.
What is
what I
my
have
learned
stated.
friend saying?
That is
The
what-
bank forwarded this forensic audit report
Well,
on
I have not-
26th of December
till now,
2024.
till now, neither have disturbed others. Malu, kindly take
It's all
paragraph
right.
5, only one sentence.
আমি তোর others বললাম।
Only one sentence, my lord. Based on the forensic audit report, the reasons for observance of the account as fraud.
In the show cause notice checkup, apart from forensic audit report, there is mention
Balance
of other
sheet,
documents
yes.
also.
My lord, then my lord has to go. My lord has to look into the entire show cause notice. My lord, kindly
have been appealed.
only one sentence, my lord, for the purpose of my satisfaction, my lord, only one sentence as my submission.
No
One
further
sentence as my
satisfaction,
submission.
enough satisfaction. পরেরটা রাখুন।
My lord.
Yes. Cancellation of bid in the
Yes,
techno-commercial
the
state.
last occasion when I moved this matter, my lord, Lordship was pleased to direct me to serve notice of my
Yes,
honored friend.
right.
He's supposed to bring
The instruction.
Yes, my lord, I have not received any instruction as yet because on that day I was, my lord, absent.
No, but then when was the copy served upon you?
Yes, it was served on 28th.
Then
I have-
next day?
I have sent it 28th. Thereafter, I was out of station. That's why it has been communicated to me anyhow. Wherever I asked, today I asked, but today is the office is closed. Now, I think there is no scope of interim order, my lord. Kindly see the tender which was issued on 2024,
Page
page 32,
32.
and petitioner participated in the tender process.
Yes.
Subsequently, a list was annexed in the writ petition. I don't know the date of the list. Therefore, it appears that he has not been qualified in respect of 8M South Bengal category. There is 8M is well a poll size. And in respect of South Bengal, he is not eligible. Reason I have to, my lord, gather from.
my lord,
But
my learned
in
friend
the-
is submitting,
in the-
that there
in
is
the-
no urgency in the writ application.
In the-
This is a rate contract. I have to enlisted as a rate contractor in the, after that I can participate. There, after passing of this order, there are other two tender already been floated. I could not participate only on that ground.
He
that
cannot participate in the contract process if his name is not enlisted.
That is why. What is the reason for holding me to be not eligible?
In the ground which I have found that he has, my lord,
No, your finding will not do. I need an instruction from the authority itself.
well, let it be fixed any other day on the next week, my lord. In the meantime, myself, because today I have the office.
Learned advocate appearing for the WBSCDCL seeks further time to take positive instruction. specifying the reason for cancellation of the petitioner's bid in the techno-commercial stage. Stuff on such prayer released on 10th, next Wednesday.
As a lordship, grateful to your lordship.
Hunda.
My lord, may I audible, my lord?
Yes.
Here the short point involved in this petition, my lord, debarment of the petitioner to participate in the tender process cannot be perpetuated since 2020-23, but in view of the Honorable Supreme Court's order. And my lord, in the earlier occasion, in the summer year 2023, his contract was cancelled and the performance security has been forfeited. Thereafter, writ petition has been moved.
Who are you
and the matter
representing?
For all of the respondents.
All of the respondents.
and the matter is now pending before the arbitrator in view of the division bench judgment. My lord, passed by the division bench judgment, my lord, page 40.
So why are you here?
My lord, I have not been allowed to participate in any tender. My tender has been rejected on the only sole ground that in the workload return, my name has been in my name, no has been initiated. Page 46.
List of contractors having no load, but banned. Are you a banned contractor?
My lord, in the year 2023, writ petition was moved and the matter has been now pending before the arbitrator in view of the division bench order.
Very well. So still now the ban remains.
And in the order, my lord, page paragraph 33, my lord, page 35. You know, kindly come to page 35.
Yes. Yes.
Page 38 is the relevant portion, paragraph 12 and paragraph 13. Paragraph 13 is the relevant.
Paragraph 13 is relevant. Yes.
But pursuant to the order passed in the paragraph 12, my lord, the arbitration proceeding is pending. And my lord, in that arbitration proceeding, my lord, the question of debarment has been raised in view of the order passed in the passed by the division bench. That has not been considered. My lord, without considering this, my lord, and keeping the matter pending, my lord, my participation in the first tender, my lord, has been rejected. My lord, page 30, page 20, 30, page 33.
Yes. We have received this brief recently, leadership, so we need to seek directions
Please
from
come.
the department.
The petitioner.
And my lord, your lordship, I am guided by the Honorable Supreme Court's order.
If the we will file our
The petitioner is aggrieved by the act on the part of the respondents in not permitting the petitioner to participate in any tender process, since the petitioner has been banned. Stop. The not the challenging the order of ban. The petitioner approached this court by filing a writ petition, and the writ petition and being aggrieved by the order passed by the learned single judge, the petitioner preferred an appeal before the Honorable Division Bench. Stop. The Honorable Division Bench, vide judgment dated 21st April 2025, was pleased not to interfere with the order of ban. Stop paragraph. The petitioner submits that in view of the order passed by the Honorable Division Bench, the issue of ban is currently pending adjudication before the arbitrator. Stop. It has been submitted that the petitioner cannot be banned for eternity. Stop. The authority ought to permit the petitioner to participate in the bidding process. What is the judgment that you are relying upon?
But the Honorable Supreme Court recently passed a judgment that the banned order cannot be perpetuated.
Cannot be?
Perpetuated.
Perpetuated, yes. 2025.
Page number 2, my lord.
Page number 2, which portion?
Order portion. Paragraph number 9, sorry, my lord. Page number 3, paragraph number 9. Yet the court allowed the debarment, cancel the debarment.
Yes. When was the debarment order passed?
But in 23.
23
Your lordship kindly come to the WLR June 2023.
কি বললাম?
Page 46.
The authority would not permit.
ঠিক আছে. Reliance has been placed on the judgment delivered by the Honorable Supreme Court on 4th August 2025 in numberটা লিখে নেবেন তো, wherein the court observed that the order of debarment does not specify any period for its operation. Where is your order of debarment?
Page number
My lord,
40.
Page 46. No order, only workload return. Serial number 102.
Starting from page 40, my lord. Operating portion, page 46, serial number 2.
102 at the top.
On the sixth column, it's written no.
No flow progress. Only this. Only this. And it has been my lord mentioned in the rejection of the tender, my lord, page 33.
It appears that in the instant case, the authority noticed the slow progress of the petitioner and was not agreeable to allow the petitioner to handle more load. Stuff.
But this is of June 2023.
The validity and correctness of the said order is pending consideration before the arbitrator. Stop. As the Honorable Division Bench has not, Division Bench was pleased not to interfere with the order of ban and granted leave to the petitioner to approach the competent forum for remedy, and the matter is currently pending before the arbitrator. Accordingly, the court is not inclined to exercise jurisdiction in this matter.
There is just some time may be given to
it will be open for the petitioner to pursue the matter before the arbitrator, and arbitrator stop. It is expected that the arbitrator will conclude the process at the earliest, so that the petitioner is not held up any further because of the order of ban. The writ petition stands disposed.
But your lordship kindly figure a time limit may be fixed, my lord. Otherwise, my lord, petitioner has not been allowed to participate in any tender process, my lord. Your lordship kindly fix the time limit, my lord.
I have mentioned at the earliest. Yes, please, 29.
For the petitioner. It is a classic case, my lord.
It is
It's a classic case, my lord, where a power has been misused
All
by
right.
the officer concerned, my lord.
Which
My lord,
officer?
My lord, it is a, I'm challenging the West Bengal State Electricity, my lord, Small Scale Industry, West Bengal Small Industrial Development Corporation Limited.
WBSIDCL, who is appearing?
Now, my lord, work order was issued in my favor, but I am the person, my lord, the contractor who has executed more than 500 satisfactory contract of various departmental authorities for installation of street light, my lord, at Santoshpur Industrial Park, my lord. My lord, Integral Park, I was engaged. My lord, in terms of this, my lord, I had completed the entire work within 2023, my lord, December 2023. Thereafter,
What is the ground for which you have not been permitted?
my lord, I have completed the work. Work was completed.
What is
Yes,
your
please
prayer?
don't say no.
What is the prayer?
My lord, kindly see, come. Thereafter, after completion of the work, my lord, they issued a letter, my lord, that on 12 number of arms, my lord, the street poles angle should be from L to V.
Yeah, there is an order of blacklisting.
There is an order of
Please show me.
there is an order that I should not, my contract is rescinded.
Show
That is
me,
8th May
please.
2024.
Please show
25
me.
later, my lord, which is at
এই
page
এগ্রিমেন্টটা কোথায় টার্মস এন্ড
105.
একটু রেডি হয়ে থাকা উচিত Some foundation, terms and conditions.
Before that, my lord, kindly come to
With reference
104.
show cause notice after.
ওইটা পেজটা লিখে দাও P30
So cause notice was given 27 November, 21st November
হচ্ছে P30
2024, which was being replied to.
পেজ পেজ হচ্ছে 104
Yes.
If your lordship kindly come to page 89, that is more important, my lord, which contains the reason and the ground.
But this is the final order, isn't it?
Final order, but the
Right.
final order does not have any reason. The reason are given in the letter of 21st November 2024, which is at page 89.
All right.
পেজ 89 কি বলছে লিখুন
My lord, the ground which has been given is this, that the time was extended till 30th November 2024 to complete the work,
পেজ 89 to
and you have not submitted the revalidated bank guarantee,
পেজ
and
89
also not taken up the work at site, and have intentionally delayed the progress of work at site, and accordingly have failed to execute the proportionate work in proportionate time. In view of the same, you are therefore directed to show cause as to why action should not be taken against you for breaching the contract as per clause 2 of the agreement. Clause 2 of the agreement means, my lord, that they will impose some compensation, fine, to the tune of 1%. That is clause 2. After this letter was being given, my lord, we caused reply. And caused reply to this letter, which is at page 92, my lord, the detailed.
No, it's all right. Is there any
Thereafter,
scope to interfere in
my
this
lord,
matter at
yes,
this stage?
my lord, only scope is one, my lord, that I'm not, I know, my lord, that today my entire payment has been withheld. They have adjusted the
It is
entire
not
payment. Yes, it is correct. But what I'm submitting, they've invoked the clause 3 thereafter by the fine, and they have rescinded the contract. Several tenders are being issued by the
এবার
state
দিতে
of
পারবো
West Bengal,
স্টেটমেন্ট
whereby, my lord, a person who's one of the contract has been rescinded, he will not be able to participate in the other contract. So, my lord, what I'm submitting as of the interim order, my lord, let them file affidavit that this order, my lord, will not prevent me from participating in any tender if I am duly qualified to participate.
And then you will repeat the same thing.
No, my lord, I can show, my lord, 500 contracts I have completed successfully.
What is your
This has been
submission?
completed also.
What is your
There's no
submission?
fault on my part, my lord. I can satisfy your lordship on the documents.
WBSIDCL, what is your submission?
My submission is that first of all, my lord, the writ petition is
Not
not
maintainable
because it is the my lord,
Contractual.
with the private GM.
Yes.
My lord, in view of the fact that my lord, the Supreme Court said if your lordship kindly have a
Yes, yes,
one
I
paragraph
understand.
that it is
Understand.
not a statutory contract.
Yes.
It's not a statutory contract. One
Right.
of the party may be the my lord, the organization, maybe the corporation or my lord, state.
Yes,
Still,
yes.
it is not a statutory contract. Number one. Number two, if your lordship kindly have a look, my lord, that my lord, this is arising out of the agreement and or contract. If your lordship kindly have a look, my lord, only one page, page number 35. Page
See,
number
there is no
35,
scope for an interim order.
there is no scope.
Please.
There is no scope.
The petitioner is aggrieved by the invocation of clause 3A
That is at page number 35.
of an agreement.
We have invoked clause 2, then only clause 3, the second stage. And he has come not against clause 2, but against clause 3 and 3A.
Of the agreement, and the contract of the petitioner stood rescinded. Stop. The learned counsel representing the respondent authority raises a preliminary objection with regard to the maintainability of the writ petition. Stop. The respondents are directed to file their affidavit in opposition within a period of 1 week after reopening of the court after the ensuing Puja vacation. Reply, if any, within a fortnight thereafter. Liberty to mention the matter for hearing. Stop. The point of maintainability of the writ petition is kept open.
Well, only submission which I was making, my lord, that my entire work has been completed in 2023. I have submitted the keys also
Until
of
I
the
leave
panel
the
keys.
there is no
and
scope for passing any interim order in this matter.